Good afternoon, councillors and those who join us at our meeting for today. At 1 p.m, can I officially declare open our meeting? Please be seated. In opening the meeting of the 23rd of February, I pay my respects to the traditional and original owners of this land, the Palawa people. I acknowledge the contemporary Tasmanian Aboriginal community and recognise their enduring and continued connection to land, sea and culture. I recognise a history of truth which acknowledges the impacts of colonisation upon our First Peoples. And I commit to a future that listens to and respects Aboriginal stories, culture and history. In opening the meeting, I note the apology from Councillor Britton, who is on leave, and note as Councillor Walker and Deputy Mayor Garwood make their way to the table that all councillors other than Councillor Britton are present. Councillors, in point 2, mayoral acknowledgements. A few short weeks ago, on the 6th of February, 2 devastating earthquakes killed more than 46,000 people in Turkey and Syria and left thousands more injured or missing. The destruction and suffering from this natural disaster is widespread. Sadly, the death toll is likely to rise further, with many people still unaccounted for. In Launceston, we know that there are many members of our community with links to those countries, and we understand that Councillor Raze himself has family connections to that part of the world. So I'd therefore like to ask all of us to bow our heads for 1 minute's silence in memory of those who have lost their lives and in support of all those who are affected by this terrible disaster. Thank you, councillors. Councillors, the second and final announcement that I wish to make concerns the memo that I've placed at your seat. It concerns my commitment at the election to at least encouraging my council colleagues to have a valid Working with Vulnerable People check. I draw your attention to the memo that I've provided, strongly encouraging us to demonstrate leadership, and if we're not yet in possession of a valid Working with Vulnerable Person card, to consider taking the steps as outlined in the memo. We note that councillors who are serving on the Council's Youth Advisory Group, YAG, are required to hold a current registration, and that Council will cover the costs associated with the Working with Vulnerable People card. So it is my strong hope, as documented in the memo, that we will all lead by example and hold a current Working with Vulnerable Person card, as I feel that in performing our role as councillor, where we are required to interact with vulnerable people, that you will follow my lead. You'll note that my Vulnerable Person card is attached to the memo and that you will consider taking out the steps required to obtain one as well. Could I also make welcome, we have 2 MLCs who are joining us at our council meeting. We welcome the member for Pembroke and the Shadow Minister for Local Government, Luke Edmonds, together with the member for Launceston, Rosemary Armitage. A big welcome to both of you, and indeed all of those that are attending our meeting. A reminder that the meeting is live streamed and recorded. If our mobile telephones could be switched to silent. Item 3 of the agenda is declarations of interest. In accordance with Part 2, Regulation 8.7 of the Local Government Meeting Procedures Regulations of 2015, elected members are requested to indicate where they may have any pecuniary or conflict of interest in respect to any matter appearing on today's agenda. Are there any councillors wishing to declare such an interest? There being none, let's move to item 4, the confirmation of the minutes, that the minutes of the meeting held on the 9th of February be confirmed as a true and correct record. Someone to move that motion? Councillor Harris has moved. A seconder? Councillor Palmer. Councillor Harris, any corrections or comment? Let's put the motion to the vote. All those in favour raise their hand. That is all councillors present, and the motion is carried. Item 5, council workshops, concerns the workshops held on the 9th and the 16th of February. Recommendations contained include the content covered together with the attendance of councillors. Someone to move that motion, that recommendation? Councillor McMahon, thank you. A seconder? Councillor Harris. Councillor McMahon, do you wish to speak to the motion? Councillor Harris, do you wish to speak to the motion? Any councillor wish to speak to the motion? 5.1. Let's put the motion to the vote. All those in favour raise their hand. That is all councillors present. The motion is carried. There being no councillors' leave of absence applications, we move to item 7, community reports. And today we welcome Kirsty, who's the owner and founder of the Redress Hub, to share with us the great work happening in that space. Kirsty, a big welcome to you.
Thank you. Good afternoon, Mayor Gibson and councillors. My name is Kirsty Marte and I'm here to introduce you to the Redress Hub. Did you know that in northern Tasmania, textile waste is the second largest waste item found in our domestic bins by weight and the third by volume? The textile and clothing industry is locally, nationally and globally one of the largest polluters. At the Redress Hub, we aim to reduce these impacts through local actions and a circular economic approach to keep clothing in use for longer. This is through reuse, remake, repair and resale. We do this by providing 3 main services. The first is education through skills workshops and information. The second is resale, remade and repaired products for sale by local designers and makers. And thirdly, we offer professional advice on the circular economy to local businesses and organisations. Our workshops provide skills to help people keep their clothing in use for longer, such as repair and remaking anything from sewing on a button to remaking old clothing into new. To date, we have had over 70 participants attend more than 20 types of workshops since we opened in September last year. While these lifelong skills can reduce consumption and waste, they also create important social opportunities for many in our community. We have overwhelmingly support from the community, as well as financial support from the local Great Regional City Challenge, which actually helped us kickstart our venture. We have had political support from Lara Alexander and Michelle O'Byrne, including a parliamentary speech, as well as industrial support from City Mission and the Waste and Resource Recovery Board. They've been critical for the Redress Hub's success. We have been receiving increasing requests for us to support local communities in need, to provide skills development, social engagement, and to have skills that actually save them money. This is an important aspect of our tenet as a social enterprise, and to give back to the community through our purpose, keeping clothes in use for longer. Collaborating with local businesses, organisations and institutions is another aim for the Redress as a social enterprise. Developing business collaborations such as a commercial felting loom we'd like to obtain to felt all types of textile waste into new fabric is one such ambition. So thank you for your time today and opportunity to present an overview of the Redress Hub. We really hope that you'll come and visit us at the Quadrant Plaza just behind Toy World sometime soon. Thank you very much.
Thanks, Kirsty. We certainly congratulate you and the other members of the team on this great initiative. All the very best with it. Item 8, public question time. 8.1, public questions on notice. We note the responses to 8.1.1, Citizens Assembly, 8.1.2, Advisory Committee, 8.1.3, the QV MAG Management, 8.1.4, the Birchells Building Expression of Interest, 8.1.5, the Albert Hall Development. 8.2, public questions without notice. I'll ask Elizabeth to read our guidelines.
If you're participating in public question time, please move to the microphone and state your name and address. You may then ask up to 3 questions. Please direct your questions to the Mayor. The Mayor may refuse to accept a question. If this happens, reasons will be provided. If your questions are accepted, they will either be answered at this meeting or taken on notice and answered at a future council meeting. Debate or discussion about questions or answers is not permitted.
Thank you, Elizabeth. Invite any members of the public now to come forward with any questions.
Thank you, Robin Smith, on behalf of Coffee Republic. I'd like to ask a question about the survey on PMD's personal mobility device scooters in the attachment of today's agenda as it relates to an item. The report, I'm normally very supportive of reports written by council officers as a good talent.
Just in front of the microphone, Mr. Smith.
But it seems to be, and forgive me, but it seems to be light on feedback, whether that be the feedback council received or through the 2 operating companies. Why do I have that opinion? Is it doesn't seem to appear. There's a few statistics about feedback, but the problems don't seem to be reflected in here that I hear on the street. So it seems a bit light on that. And if that is the case, would that be a missed opportunity?
Thanks, Mr. Smith, for your question. Obviously, this matter will be considered at 15.2. Councillors have heard your question, and that can be unravelled further when we get to that agenda item.
Thank you. Previously at a meeting, I asked about the laws on the use of the PMDs, where they can be used, roads and the control of them, etc. And I don't want to misquote the officer, but essentially they could be used with the exception of those areas that are marked in the CBD as a no-go zone. I look at the image on page 492 of the report, and it has 2 individuals riding a scooter. By all accounts, could you tell me, I can't work out whether that would be legal use or not under the road rules. It's a promotional shot. It has 2 individuals outside your office, Mr. Mayor, just here on the footpath. I understand the PMD road rules don't apply because council hasn't actually gazetted or gone through the processes for banning in any part of the city on footpaths the use of PMDs, whether they be the approved trial scooters or personal. So on page 492, could you tell me, would council consider that legally correct or not, please?
So again, and I'm not fobbing off your question, we'll consider that when we get to item 15.2, specifically with regard to the rules and the geofencing that you've highlighted. I've made a note of page 492 and the image used there, and when we get to that item, we'll unpack that further.
Thank you. And finally, this is a council report, but it gives examples of Beam user survey comments on page 14, which is the page 460. The comments, could I take those as being feedback? Are they real comments, would you say, from users, or are they a media marketing suggested illustration of what user comments might be.
Thanks, Mr. Smith. The same response. Other than that, I'll say we've worked really closely with both providers up until very recently and one in the last month. That's been weekly conversation with the providers, very open conversation. So one would expect that those comments are genuine feedback that's been captured during the 12-month trial. But again, we'll unpack that further at 15.2.
Thank you, Mr. Mayor.
Are there any additional questions? What's the point of order, Councillor Walker?
Point of order, just insofar as it is questions from the public without notice, and depending on how we unpack, as you say, at that item in 15.2, those questions may or may not be answered. Will those questions still appear in the following agenda and be answered if that is the case?
So thanks for the point of order. The questions will be answered because I said that they would be in the item when we get to 15.2. That's my commitment to Mr. Smith. Any subsequent questions from the public? We now move to item 9 of the agenda, petitions. We'll invite Elizabeth to read the guidelines to members of the public speaking to any agenda item. Thank you, Elizabeth.
If you are speaking to an item on today's agenda, the Mayor will invite you to come forward to the microphone. Please state your name and address. You may speak for up to 2 minutes, either for or against the recommendation. You will hear this sound
Just the sound.
when you have reached your time limit. You may not ask questions or enter into debate with councillors or council officers. Your statement is not to be defamatory, inappropriate or abusive or be intended to embarrass any person. The Mayor may direct you to stop speaking if you do not follow these rules or if your statement repeats points that have already been made.
Thanks, Elizabeth. And noting that we do have a large number of speakers today, we will be enforcing the time limit. So when the buzzer rings, you will be required to finish the sentence that you are articulating. 9.1 concerns the petition, the installation of public toilets at Youngtown. There are no speakers listed for 9.1. Just double checking, Elizabeth, that no one has arrived subsequent to that. Thank you. Seeking someone to move 9.1. Moved Councillor Harris. Seconder, Councillor Mackenzie. Procedural motion with regard to receiving of a petition. We'll put the motion to the vote. All those in favour raise their hand. That is all councillors present. The motion is carried, and we note that a report will be brought back to council within 42 days to determine any action to be taken with respect to public toilets at Youngtown. Item 10, Planning Authority. Under the provisions of the Land Use Planning and Approvals Act 1993, Council acts as a planning authority in regard to the item included in agenda item 9, which is item 10. My mistake. 10.1, Golconda Road, Lilydale, passive recreation, development of a rail trail, associated works and development of a vehicle parking area at the Lilydale Falls. The first speaker I have listed is Ian Bassett. Welcome.
Thank you for hearing me. My wife, Ian Bassett, 320 Michaela Road Tunnel. My wife and I have a farm at 320 Michaela Road, and we have sheep and cattle and have to be accredited to sell stock. We have 2 kilometres frontage to the railway with 7 drainage points off the corridor, 5 culverts and 2 creeks. The creeks have giant freshwater crayfish, which are very sensitive to toxins. 2 culverts drain into a stand of rare paperbark tea trees, which are a big asset to the property. Tests carried out point to a large quantity of toxins in the formation that that, if disturbed, will leach into the surrounding waterways onto our property, and if any of them are picked up in the livestock, our property will be shut down and pretty much become worthless. Also, the proposal to open it up to the public will give opportunity to biosecurity and theft risk. It has taken 70 years to develop this property, so we are concerned for its future viability. As to the proposal for the falls ground, if it becomes too overcrowded, it may put a lot of people off stopping there. There were 17 campers there with caravans and campers last night, and it has limited space. As for Lilydale Township itself, it has very limited space, and even now, some days with trucks in the street, one has very little room to move. We are not against the rail trail per se, but if our property is banned from trading due to any toxins in the meat, 70 years of work will be for nothing.
Thanks, Mr. Bassett. That is your time. We really appreciate your contribution. Our second speaker listed is Rod Cooper. Welcome.
Thank you very much. Rod Cooper from 9 Eaglesdale Place in Wynyard. Just, I'm actually speaking to, not for or against. My concern is that what occurred at Dorset has placed Dorset Council basically liable for any environmental harm that occurs from that section of the rail, and I just want to inform Council so that they're aware of the process. And now, just an example, in Victoria, a number of years ago, Council subdivided some land next to their landfill, and they built, and the houses were built there, and then some years later, methane gas was leaching into the houses, and Council was liable for the removal of the houses, remediation of the soil, and putting a buffer zone around. The result of that was C14 of the planning scheme, which is the state planning scheme in Tasmania. I am the only certified environmental contamination specialist in the north of the state, and so therefore I do what C14 requires, which is a preliminary site investigation. Now, this is not a construction environmental management plan, which is what Dorset have in place and what you have in your DA. The PSI must go before the decision is made to proceed with the development. Sorts of things like the Inveresk rail development, the gas works here. I did a preliminary site investigation, and as it says in the planning scheme, I make a statement that the land is suitable for its intended use. What that does, at that point when I sign that and give that to Council, is that Council is not liable for the impacts of that development.
Thank you,
I need
Rod.
to stop there. Now, I have written a quick rundown, but basically I think Council needs to look at the process.
Thanks, Rod. We appreciate your contribution and presence today. Next on my list is Elizabeth. I think it's Elizabeth Cute. Thank you. Welcome.
Hi, I'm Elizabeth Cute. I live at 86 Ravenswood Road, and I have some land at Labrina. I am here to oppose the proposed development of the car park at Lilydale Falls, which will in turn allow the stretch of the railway between Scottsdale and Lilydale Falls to become a bike track. My main concern for me is the social and physical environmental damage this proposal will have on my property and the surrounding area, which will cause personal financial loss for the proposal if the proposal goes ahead. Way back in 2004, I purchased an internal block of land in 21 Butlers Road and developed and created a weekend escape. I am fortunate enough to share a property boundary with a beautiful Denison Gorge, and I have a railway corridor that divides my land into two sections with streams and underground springs. I've spent the last 18 years creating a peaceful haven and weekend getaway. Now with major retirement dream is to move there. If this proposal was to go ahead, all this work, time and energy will be gone in an instant and will no longer have the privacy that this land offers. It is well documented that the ballast along the train line for which this proposal wishes to turn into a bike track is full of toxic, extreme arsenic and asbestos. It would lead to detrimental and catastrophic environmental damages to the local ecosystem all along the proposed track, including my land and into the Denison Gorge. If this proposal was to go ahead, the release of these toxins in particular will cause irreversible damage to the environment. I have 72 acres and half of this land is in plantation forest. This may not be significant to any of you, but to me it represents 17 years of hard work and the pleasure of stress-free private oasis I've enjoyed with my family and friends.
Thank you, Elizabeth.
Mr Ferguson is going to compulsorily acquire that if it goes ahead as well. I have 4 acres, which is most of my track, and I've got a picture here that I'd like to...
Thank you. That is your time as Councillor McMahon passes the picture around. Thanks for being with us. The next speaker is Wendy McLennan.
Mr Mayor, councillors, I'm here speaking on behalf of Mary Ziegfeld, who lives at 100 Ferny Hill Road, Golconda. So the words I'll be speaking will be her words. I own a property on Golconda Road and also at Tunnel Road. I have a 1.2 kilometre frontage of railway bordering my property at Golconda, which has runoff from the railway. The first issue I want to raise is that there has been no consultation with me over the whole 5 years or 6 year period that this project has been mooted. I want to know who will be accountable for contamination of my property from toxic runoff of the railway line if the ballast is crushed. These papers, the statement of evidence by Rod Cooper, the environmental scientist who you've just heard, states that there is quite a toxic runoff when it's been raining. I don't think people are aware and understand the consequences if my cattle eat or drink contaminated grass or water. It goes into their system, into the meat. Then when it's time for them to be sent to Greenhams for slaughter, their meat gets graded and tested for quality. They can even tell if the beast has been stressed from the pH of their meat. If there is a problem with the meat, such as chemical residue, bruising, they get rejected. Hence, I don't get paid for them. I lose my accreditation through Greenhams and LPA, which us as farmers must have, understandably, to produce quality meat. We also have to fence off any sheep dip areas because of the toxic chemicals that were used years back. Cattle were not allowed to drink from old bars because of the lead paint, cannot leave any batteries sitting about, they contain lead, and this is how particular they are. Yet council suggests it will be okay to graze my cattle on toxic runoff from the crushed ballast. This is my livelihood, my only income, and I take offence to being referred to as just a small-scale hobby farmer. My daughter will be living on the farm shortly with her daughter, and I don't want them being poisoned or getting sick from carcinogens. Thank you.
Thanks, Wendy, and pass on our thanks to Mary. Our next contribution is from Paul Kabauser. Welcome.
Thank you, Mr Mayor. Thank you, Mr Mayor and councillors, for the invitation to speak on the petition. Can you hear me all right? Thank you. I've written 3 versions of the paper to ensure that you have read the story. All the railways are contaminated. The Victorian government has passed a law that all ballast off a railway was to be deep buried, meaning in the ground, covered over. North East Railway line has 40,000 metric tonnes to be transported to Copping, which is the only place to take deep burial product in Tasmania. 40,000 tonnes at $400 a tonne will cost $16 million. The on-site loading into trucks and cartage will be at least another $4 million. We're talking about $20 million plus. After speaking with the Mayor of Dawson and explaining this, it was dismissed as a joke. I've had over 40 tests done on the North East Railway line by a qualified environmental scientist, which spoke earlier. The rail information and ballast has been in place for over a century, subject to the pollution from locomotives, rolling stock and weed killers. If the railway is left in place, there's no issues. The removal and crushing of the ballast, as put forward by the Dorset Council, will release toxic poisons into the environment with consequent risk to environmental values surrounding waterways and adjacent farming land and directly to human health and livestock. I produced a report on arsenic contamination that was killed several horses, which everybody's got a copy here now. The Chief Forensic Scientist of Australia found that it was arsenic leaching from the railway. After railways are contaminated, all railways are contaminated. I employed a qualified environmental scientist and who concluded 30 samples. They went to Melbourne to be done professionally as the council considered the liability of the project going ahead. The reason is the likelihood of arsenic poisoning during the process of crushing. Oh shit, I'm out of time.
You can finish the sentence you're on.
Sorry?
You finished the sentence you're on.
Crushing some estimated 17,000 cubic metres railway ballast along the 40 kilometres of line is reasonably the soluble content of the bulk anyhow. But there's only that bit to go that I can leave it all.
Thanks, Mr. Kabauser. We appreciate your contribution and the written elements of that as well.
Thank you, Mr. Mayor.
Thank you. Next, we welcome Michael de Bomford.
Good afternoon, Mayor and Councillors. Michael de Bomford. I live at 1 Hurst Street, Lulworth. As an appellant who took Dorset Council appeal to appeal because I was not a landowner, I was excluded from raising matters regarding effects of adjacent agricultural land use and the environment, which is state policy. During the trial, I could not address the corridor contamination under the potentially contaminated land code E2. The purpose of the provision is to ensure that all development and particularly contaminated land does not adversely impact on human health or the environment. Deficiencies in the planning scheme, I was restricted to water quality aspect only, even though dealing with in historical contaminated land use. This recreational trail development involves many kilometres of land tenure, involving multiple waterways, wetlands, agricultural and private land uses, also the ecosystem. Pursuant to Section 57 of the Land Use Planning Approvals Act, planning requirement representations, feedback from the public to the development application, it is noted of the 34 representations, 29 being a majority were strongly in favour of the retention of the rail infrastructure, also having major concerns effects on farming and agricultural land use. Planning response does not adequately answer or ignores issues. Rail trails just become another unsupervised gravel road, easily accessible to anybody and everything. It is well known that all railways are contaminated and that ballast material is taken away and stored and as deemed contaminated material and is treated at $350 a cubic metre. I've been involved with heritage rail organisations for over 40 years, and it's a standard industry practice for waste coal ash from locomotive boilers to be deposited onto the rail line, including lubricants and fuel oils, for over 100 years. Tasmanian coal has an analytically high content of heavy metal concentration, with the main toxic substances being arsenic and cadmium. Treated wood sleepers also contain arsenic and creosote, which can leach into subsoils.
Thank you, Michael. We appreciate your contribution today and in the written submission.
Yeah, the tribunal on the hasn't followed. Yeah, I just want a very important aspect. Heavy metal contamination has not been adequately addressed by the tribunal and followed up by the EPA. Thank you.
Thanks so much. Next on the list is Greg Stewart. Welcome.
Hello, I'm Greg Stewart from 43 Mason Road, Brady's Lookout. I don't agree with or support the trail on this railway track. Vulnerable species Linking to the Biodiversity Code, vulnerable species are becoming extinct in ever-increasing numbers in Australia, and the North East Railway line traverses the habitat of one of our own vulnerable species, that being the 8 centimetre orange-brown Mount Arthur burrowing crayfish. They are found only around Mount Arthur and live in banks and ditches in the area. Before moving in heavy, noisy earth-moving equipment to remove rail line and crush gravel, releasing toxins and trample on their earth tunnel homes, a full independent survey study should be undertaken on the total line to assess the presence of this species. If the rail trail development is found to endanger the Mount Arthur burrowing crayfish, the location of the maps for this species suggests, then a rethink of the proposed rail trail and the havoc it will unleash on the environment needs to be considered. Vulnerable species and their well-being should always come before perceived human wants. Perhaps an alternative route can be found for the cycle trail, eliminating the need for major earth disturbance. Thinking in the lateral way can sometimes bring harmony to a very divisive argument within the community. There are many alternative pedal-powered devices that do not require removal of the railway line, and they actually use the existing line. Launceston and North East Railway have built 3 of these 4-wheeled, 4-seat pedal devices for use on a 4-kilometre section of the North East line. A great healthy alternative using existing infrastructure. So why rip up the line at all? Thank you.
Thanks, Greg. Next on the list is Diane Venn. Welcome.
Thank you. Good afternoon. I'm Diane Venn, 130 Lalla Road, Lilydale, second generation farmer at Tunnel, with over 800 metres of boundary adjoining the railway reserve. We are accredited beef producers. This farm has several waterways. There has never been any inclusion of the wider community in any consultation process by Dorset Council. The attitude is you will have this whether you like it or not. The LDPA represents less than 10% of the immediate township population of Lilydale, less for the wider community. This DA does not represent in category the nature nor significance of the implications of contamination for adjoining landowners or the threatened species existing on our land. It does not recognise the state policy on protection of agricultural land 2009, which gives priority to the importance of agricultural land above other developments. This corridor is an industrial site of magnitude. Kilometres of potentially deadly heavy metals, if released, including arsenics, hydrocarbons, and hydrocarbons. It is not a city footpath, nor should be assessed as such. Whatever the category, it remains a contaminated industrial site. Temporary silt traps, environmental water monitoring, if Dorset does it. What if heavy metals, arsenic, hydrocarbons are detected off the railway reserve if this goes ahead? What then? The contamination genie is out of the bottle? We lose our accreditation livelihoods and agricultural land becomes worthless.
Thank you, Diane.
Who is accountable? Launceston City Council, if they pass.
Thank you. Next, we welcome Stuart Bryce.
I have a submission for Stuart Bryce, Chairman of the North East Residents and Farmers, opposing this DA. Since the rail trail was first proposed in May 2015, NERAP has actively opposed the removal of any rail infrastructure for any other purpose. The grounds then and remain the same: safety, security, privacy and biosecurity. 3 surveys to the community provided 65% plus support for the retention of the railway. These surveys have been ignored by Dorset Council and the state government. Biosecurity has come to the fore following test samples taken from the railway from Scottsdale to Lilydale Falls. These samples consistently demonstrate substantial quantities of hydrocarbons, asbestos and arsenates that have accumulated over 120 years of use by diesel, electric and steam locomotives. The arsenates are residue from weed control, now no longer used. Arsenates are present in quantities exceeding the limit for human presence in ballast and subsoil under the railway, as attested by contamination specialist Mr. Rod Cooper. Disturbance will risk the transfer of these contaminants into ground and surface water. There's a number of farms on either side of the railway that have accreditation for their agricultural pursuits. The release of these contaminants will threaten accreditation, stock health and livelihood. The presence of arsenates in the disturbed ballast present a risk to users on foot and to a lesser degree on bikes. Practice by railways in both Tasmania and Victoria requires that ballast from disused tracks be deep buried. Thank you.
Thank you, Diane. Next is Rudy Valentino. Welcome.
Thank you. Good afternoon, everyone. I'm Rudy Valentino from 195 Lalla Road. I'm talking on behalf of the Lilydale District Progress Association, which has been represented in the Lilydale community since 1968. As a result of concerns raised by the LDPA, Dorset Council's DA was deferred last year to enable consultation with the Lilydale community over the proposed parking arrangements at the Lilydale Falls. We have enjoyed a good working relationship with Dorset Council, which have been keen to work with our community to deliver the best possible parking arrangements in the reserve. At a final on-site meeting at the end of the consultation process, a senior City of Launceston manager, 2 Dorset Council reps and the LDPA committee discussed and proposed a plan. 2 months after that date, the City of Launceston, without any consultation, changed the plan and has inserted those changes into the conditions for the DA that will be voted on today. The LDPA has no desire to see any further delays in the DA approval process. We have therefore written to the Mayor and each councillor proposing a change to item 10.1, section 3, amended plans required, that will enable the DA to be approved and the consultation process to be finalised within the community. The wording we have proposed will enable the project to proceed to the next stage while providing an opportunity for genuine consultation with the local community on issues raised by the City of Launceston after the conclusion of the previous process. On behalf of the LDPA and the people of Lilydale, I urge you to include our community in the consultation process. Thank you.
Thanks, Rudy. Next is Rowan Willis.
Good afternoon, Mayor. Good afternoon, councillors. My name is Rowan Willis. I'm the Assistant General Manager of Dorset Council and I'm here to speak in support of the recommendation being advanced to you. Firstly, Dorset Council wants to acknowledge the unwavering support from many for the Rail Trail project. Your positivity and determination to see this project become a reality is a powerful motivation for us. And we share your vision that this project, at its completion, will represent a genuinely regional recreation and tourism asset for Northern Tasmania for the enjoyment of all. Secondly, it's important to acknowledge the tremendous work of Council's consultant town planner, Mr Ashley Brooke, in his preparation of the planner's report provided in the meeting's agenda papers. I think councillors can take great comfort in the knowledge that the unsuspectingly complex legislative and regulatory framework that sits behind this project has been diligently navigated by Mr Brooks, and his report and recommendations professionally address the requirements of that framework. And finally, I want to acknowledge the wonderful collaboration we have experienced working with the Lilydale District Progress Association in preparing the revised car parking plan for Lilydale Falls Reserve. Headed by Mr Tony Nart, this association has been an absolute credit to the community it represents. The revised car parking plan strikes the right balance between functionality and amenity. accommodating existing and future users of the reserve within a confined and fit-for-all purpose development footprint. We all know that the Falls Reserve is one of the real jewels of the Launceston region, and we are confident that implementation of the revised car parking plan will help that jewel shine and complement the overall rail trail project. Thank you.
Thanks, Rowan. Wendy McLennan. In your own right. Welcome.
I was just going to say I'm speaking for myself. We received a letter from the Launceston City Council in September 2018, and at that stage the decision was made that the best outcome for the region would be for the rail trail and heritage railway to successfully coexist on the line. And the council agreed with the state government conclusion that both projects had the capacity to generate economic and employment benefits. Now, what happened was the Strategic Infrastructure Corridor Act, and I'm not sure if councillors are familiar with that, that was designed to, it was specifically designed so that before any railway was removed, it has to have the approval of the minister. So you will still have to go through that next process under the Strategic Infrastructure Corridor Act. Under Section 99(2), the Minister has to be satisfied that it's not reasonably practical or would be unreasonably costly for the designated use to occur on the land within the corridor other than on the land on which the railway track is situated, which means that you requested in 2018 that there should be alternative decisions or consideration made as to where the bike track could run and to leave the railway in place. And that was the decision of this council. And I'm not sure when that decision was rescinded. And the removal of the track has to be reasonably necessary for the purposes of enabling the use or the safe use of the corridor for the designated recreational use. So, and the Minister has to have this proved to him. So thank you.
Thank you, Wendy. Next listed is Philip Wayne. Just your address, Philip.
Good afternoon. I was only aware that this DA had changed significantly from the first one a few hours ago. I've been away and hadn't read my email. The original DA was for a car park at Lilydale Falls, very nice spot. Now it's included the removal of all that infrastructure to Waiona, which belongs to the ratepayers of Launceston, so to speak, which you represent. And to me, Dorset are trying to sneak through the removal of all the infrastructure. And I really think a fresh DA should put in, and the public, the ratepayers of Launceston should be made aware. The only thing we've had is an article in today's paper which includes the removal of, which mentioned the removal. When I glanced through the new DA, same number, the new DA, it's the removal of all that infrastructure, which I totally object to. Once it's gone, there's no chance for a scenic rail down the track, and we've got what we've got is basically a white elephant that the ratepayers of Launceston will have to support. Dorset have got their Scottsdale to Billycock Hill rail trail, which is a white elephant. There's no question about that. Does the Launceston ratepayer want another white elephant when we've got a chance for a scenic railway? Dorset claim will build cafes and shops on the roof and make employment. And I don't think anybody is going to build a cafe or roadside on the rail trail. It's not going to employ any people, and yeah, and the infrastructure's gone for life.
Thanks,
It's
Philip.
a white elephant.
Philip, could we just have your address for the record?
Oh, sorry. Philip Wayne, Dilston.
Thank you. Are there any other speakers that didn't have a chance to list their name on the intention to speak register? No. Ros, you didn't wish to speak? No. Okay. There being no additional speakers, councillors, someone to move? Councillor Harris, are you moving the recommendation? A seconder? Councillor Mackenzie. Councillor Harris, do you wish to speak to the motion?
I will. I guess there's a lot of questions that have been raised from this, and I guess probably the first question that I'd like to ask, if I can.
So you're asking questions or speaking to the motion?
Yeah, I think I'd better ask the questions first so that we get the context before we talk about it. One of the many questions being asked was about the potential for, I guess, contamination from the existing ballast being crushed to enter the waterways and contaminate the local fields around the proposed thing. Have we any advice on whose responsibility that will be, considering it is state government or Crown land and the operator is the Dorset Council rather than the Launceston City Council?
Thanks, Councillor Harris. Consultant Planner Ashley.
Well, the recommended planning permit's got conditions in there to deal with the contamination issue and potential impacts or the risk of impacts to water quality. So Dorset Council would be the holder of the planning permit. So they would ultimately it's their responsibility to comply with the conditions of the permit.
Thank you.
So that would mean the Dorset Council will be responsible for the
Dorset Council. Sorry.
Thank you.
Yeah.
Following on from that, we heard from Mr. Rod Cooper about his preliminary site investigation for remediation under C14, which he claims should have happened or is necessary because of the site, which because of the way the development application has been presented as a recreational area, it's not necessary under the planning scheme. Have you any comment to make in regard to that, if you can, please?
Ashley.
Sorry. The potentially contaminated land code, it's not applicable to the rail trail itself per se, because it's not a potentially contaminating activity that's listed in the code, and the potentially contaminated land code. And that the requirement for a preliminary site investigation arises under that code. So the contamination issue has been looked at in the DA in this planning application, but also the planning application that was considered in the Dorset Council area in relation to the water quality code and the considerations under the water quality code for impact for potential contamination of watercourses.
Thank you.
Okay, so with that, if I may, Mr. Mayor, to be sure, the previous DA that we're talking about up at in the Dorset Council area near Scottsdale did involve the crushing of the ballast as part of their application.
It's basically the same.
So there's no difference in that.
Yeah.
And as a result of what had happened, what we know has happened at Dorset,
yeah.
Are you able to tell us if there has been any contamination of the watercourses along the property of the boundaries that front onto the rail trail at all in any of the areas, and whether there are in fact similarities such as creeks and things that might cross the existing rail trail as distinct from the one that's proposed in the Launceston Council area?
Thanks, Councillor Harris.
The Dorset Council section that I referred to, the DA for the Dorset Council section was from Wyena to Scottsdale. And there was already a pre-existing rail trail that went from Scottsdale to Tongana and then Billycock Hill from there. So the DA was for the DA that was approved that was subject to the appeal was Wyena to Scottsdale, and that hasn't been constructed at this time.
Thank you, Ashley. Councillor Harris, do you have any further questions at this stage?
No, I'm happy to let others have a chance to ask.
Thank you. Question from Councillor Walker.
Thank you, Mayor. And I will, while Ashley's, the planner, is in the seat, there are some questions to him.
So just to be clear, you'll ask the questions to me and I'll triage them to the appropriate person.
By you, thank you, Mayor. So you're talking about the Strategic Infrastructure Corridor Act and the crushing of ballast. Is that something that is in the Act that governs the EPA, or something that's in the Act for the Strategic Infrastructure Corridor?
Consultant planner.
The crushing and the rail ballast. No, it's not under the Environmental Management Pollution Control Act. It's not listed as an activity under that Act, under Schedule 2 of that.
But certainly excavation is.
Consultant planner.
Excavation in the sense of a quarry, that's an activity which is listed there.
And when it comes to, we've heard mention of freshwater crayfish, for example, something that's listed as a threatened species. How is that assessed in regards to potential contamination of waterways?
Well, it's assessed in the context of the Water Quality Code, again, because they're the works that trigger the consideration. It's works within 30 metres of a water course, and the requirement is to minimise impacts on water quality, and that's the requirement that it gets assessed against.
Thanks, Ashley. Councillor Walker.
Thank you. But these are threatened species. Surely someone, if not this council, then the Dorset Council should be referring this to the EPBC for assessment before any action is taken, not after potentially waterway is contaminated.
Consultant planner.
It depends on the type of threatened species that we're talking about, and whether they are listed under the EPBC Act.
The freshwater crayfish is listed. The Mount Arthur crayfish is listed. Do you know of any evidence or otherwise that these creatures are existing, for example, in Lilydale Falls area?
Consultant planner.
I'm not aware of those. I mean, the EPBC referral process is something which exists irrespective of the planning process, the planning process under LUPA. So if there are any EPBC implications that I'm not aware of, that would be a separate matter.
And Councillor Walker, we might triage that to Catherine.
In a moment, if I may, Mayor.
With regard to that question, I'll ask Catherine if there's anything further Catherine is able to provide to that specific question.
So the giant freshwater crayfish is known to occur in the river that runs through Lilydale Falls, but under the EPBC legislation, it's not an identified important population, so it's not likely to trigger the need for a referral.
Thanks,
Sorry,
Catherine.
I didn't quite catch that. It is not a...
Identified important population.
Meaning?
That it would, because it's a vulnerable listing rather than, say, endangered or critically endangered, it doesn't necessarily trigger the need for an EPBC referral.
Is that because of the location or because of the species?
Because of the listing status as a vulnerable species rather than an endangered species.
Thanks, Catherine. Councillor Walker.
So any work that goes towards recognising threatened species, whether it be flora or fauna, whose responsibility is that in this situation?
Consultant planner Ashley.
The threatened species considerations fall under the planning scheme if there's going to be clearance of native vegetation. So that's how it's considered. Under EPBC, it's probably a broader impact that gets considered. But in terms of the planning scheme and the state legislation, it's a direct impact in terms of actual clearing. And what this proposal is proposing what this application is proposing is removal of low levels vegetation regrowth, which has happened on the rail ballast since the operation of the train ceased.
Thanks, Ashley. Councillor Walker.
Thank you, through you, Mayor, but it is also proposing the crushing of ballast, which by all accounts does contain some contamination. But what you're telling me is that the crushing of ballast is not considered a unpermitted use. It's not listed as such as something, but nonetheless it could and likely will have environmental outcomes.
It's not listed under the EPBC Act in terms of the MCA Act, Environmental Management and Pollution Control Act, as a level 2 activity which requires EPA to consider it, but it's still there's a known contamination risk with it, and that gets considered under the planning scheme provisions. So council, it's considered under the planning scheme. Yep.
And so under the planning scheme, would it be appropriate for this council to refer this to the EPA, or indeed, depending on the nature of the listing of a species, to refer it to the EPBC? Would that be an appropriate thing for this council to do?
Thanks, Councillor Walker. Consultant Planner.
No, that's not the process. So if it's not a level 2 activity, then it doesn't get referred to the EPA.
I'm also talking about federal legislation that does protect these particular species. When it comes to the Strategic Infrastructure Corridor Act, there are a large number of discretions when it comes to the removal or comes to the use of the public corridor. Can you explain what those discretions are and how this council should deal with those?
Council Consultant Planner, Ashley.
There is a general discretion which arises under the Strategic Infrastructure Corridors Act. So works within the corridor involved in establishing the rail trail. That use and development is identified as, it's required under that act to be dealt with as discretionary. So there's that overall discretion, and that applies to the works within the corridor itself. So which is basically the former rail line corridor, like the parcels which contain the rail line, excluding where it crosses roads, and excluding, in this case, it excludes Lilydale Falls as well. So Lilydale Falls Reserve is outside the corridor. So there's that general discretion, if you like, or a general requirement to deal with it as a discretionary application under the Strategic Infrastructure Corridors Act. But then there's the discretion gets the application's still got to be assessed against the planning scheme provisions. So then there's discretions which arise under the terms of the planning scheme as well. So they're listed in the report. So there's one about the use within the corridor, within the utility zone. It'd ordinarily be a no permit required use, but it becomes discretionary by virtue of that provision in the Act, Strategic Infrastructure Corridors Act. And there's discretions around. There is a contamination discretion which relates to a fuel depot, a bus depot which had fuel storage
at
Labrina on the southern side of Labrina. There's discretions around access, so crossing of roads, upgrading the existing access to Lilydale Falls Reserve. A general discretion around car parking numbers, and that's probably one that is outside the corridor because it relates to the works within the Lilydale Falls Reserve. The layout of parking, the width of the driveway, whilst it meets Australian standard, it doesn't meet the planning scheme requirements. So there's a discretion there. There's areas which are scenic protection area. along the alignment. So there are discretions as well, and then there's the discretion around the water quality code as well, which is due to the works being within 30 metres of passing within 30 metres of multiple water courses.
Great. Yep. Thank you. Councillor Walker.
Further questions, if I may. Thank you, Mayor. There's also a stipulation in the Act requiring that infrastructure not be removed if it impedes uses of the corridor. Is that correct?
Consultant planner.
This is the Strategic Infrastructure Corridor Act. Under the removal of infrastructure.
That relates to this is relating to the minister's approval to remove.
It may be. I'd have to have a look myself.
So that's a separate provision which is dealing with. So there's a need to get planning approval for the rail trail, and there's a requirement to get minister's approval for removal of the railway track. So that's a separate approval process. So I think what you might be talking about is something which is under that process.
Further question, Councillor Walker.
This is point 99 in the Act, the removal of rail infrastructure. Despite any other provision of this Act, including Section 84, a corridor manager may not remove or authorise the removal of railway track from a corridor or part of a road that extends between parts of a corridor unless the Minister has issued to the corridor manager notice in relation to the railway track, and the Minister may only issue that notice if it is not in relation to railway track, if the Minister is satisfied that it is not reasonably practicable or would it be unreasonably costly for the designated recreational use to occur.
Councillor Walker, could we get to the question again? What is the specific question, please?
The question is that there is provision that addresses the removal of railway track within the code that is relevant to this decision, and I'm just trying to drill down into what relevance that is. And I can see that people might call a point of order saying that this is not part of the planning decision, but it is in essence because we have both planning DA for a car park.
Thanks, Councillor Walker. There's no point of order at the moment. The question has been asked.
I can see that this is relevant.
Consultant planner, thank you. Well, thanks, Councillor Walker. Consultant planner, are you able to provide any further response?
Nothing further to what I said. I mean, what I said that relates to the Minister's approval for the removal.
I will raise a point of order because this is the strategic, whatever it's called, Act.
Strategic infrastructure.
Which is actually not what we're dealing with today. We're dealing under LUPA today. And if the Minister needs to make a decision in regards to the railway and removal, that's another decision which is not relevant to the decision we're making today, I don't believe.
Thanks, Councillor McKenzie. Councillor Walker.
Further questions? Thank you, Mayor. To the planner through you, if I may. We're being asked to assess this as part of the DA to inform ourselves, all councillors present, as to the appropriateness of the removal of this infrastructure. Is it appropriate for us to understand the Strategic Infrastructure Corridor Act as it applies to this situation and how it informs, through its discretions, its reference to the planning scheme?
It's relevant to the planning assessment, as I said earlier, because it has a relationship with LUPA, with the Land Use Planning and Approvals Act, in that it says works within the corridor are required to be dealt with under Section 57 of the Land Use Planning and Approvals Act. So what that's saying is it's required to be dealt with as discretionary. So it's appropriate in that context.
In which case, Chair, I would ask that the point of order be removed. It is relevant to the discussion. Thank you.
Continue with your questions.
Thank you, I will. Having a rail operation on this corridor is a permitted use, isn't it? It's not, we haven't extinguished by making it no longer part of the rail network that as a permitted use.
Consultant planner.
Well, I'm not sure what it's utility zoning, so it would certainly be an allowable use.
It's allowable use.
Yeah.
Okay, thank you. Obviously, by removing the infrastructure, while it still may be an allowable use, it wouldn't be a practical use anymore. My point here, I suppose, is that the removal of the track sort of diminishes the possible uses for the utility zone. Would you agree with that?
Consultant planner.
I do, but that's already the case with the corridor notice now. So there's a corridor notice which has been issued under the Act as well. So this is also relevant for background information as well. So the corridor notice, it declares it a corridor, declares it the strategic infrastructure corridor or a recreational corridor. It says that the corridor between Lilydale Falls and Tonganar is no longer part of the rail network, so it's no longer part of the rail network for the purposes of the Rail Infrastructure Act. And it also says that, it declares Dorset Council as the manager as well of the corridor, and it says Dorset Council may, it can develop the corridor for the purposes of a recreational trail for walking, cycling activities and horse riding as well if they like, but that's not part of the proposal.
Thanks, Ashley. Councillor Walker.
Just finally, if I may, thank you, Mayor. What we have before us is two distinctly different aspects to the one proposal. Can the planners shed any light or guidance for councillors upon how they are to assess under such different structures these two aspects and then vote with only one vote accordingly, because as has been shown, the one aspect in regards to the lines is dependent on a completely different set of rules than the other, which is the car park on council-owned land in Lilydale Falls. They're two distinct planning decisions, and yet we're being asked to make them as one planning decision today. For example, if a councillor
thank you.
with one, but
I'll stop
with
you
the other,
there. You've asked
how
the
would they
question. We'll now
respond?
provide a response. Consultant planner.
It wouldn't be uncommon for permit applications to spread across multiple parcels of land, and in doing so be subject to different zonings and different overlays. So in that case, it's part of going through the application, the land involved, all the various zonings and all the various overlays, and working out what bits of the planning scheme apply to specific bits of the proposal, and that's what's been done in the assessment and the report.
Thanks, Ashley. Councillor McKenzie.
Just following up, I guess that a large context of the conversation today has been about contamination. There's been significant responses in here, and without you wanting to respond, I guess really the overarching question for me is just simply in relation to the issues that have been raised in representation, are you as the consultant planner comfortable that the environmental requirements are being met such that the contamination issues that have been raised are adequately dealt with in the planning decision we're about to make today?
Thanks, Councillor McKenzie. Consultant planner, with regard to your report.
Well, yes, I am. So the recommendation is to include a condition or conditions around that issue, around the contamination risk issue, and which is based. It's based on it's effectively the same condition which arose from the tribunal's the Planning Appeal Tribunal's consideration of the Dorset section. So that. Whilst that also didn't need a preliminary site investigation, the potentially contaminated land code wasn't applicable. The water quality code was applicable. There was a whole lot of evidence which was presented to the tribunal around contamination. A lot of data on contamination levels, etc. That was all considered. It was determined. Yes, there's a contamination risk, but it can be mitigated by appropriate construction techniques, basically around avoiding or minimising the release of contaminants into watercourses as a result of siltation and dust as well. So. Yep.
Councillor Mackenzie.
Just a follow-up question. I guess given there's already been a rail trail from Tonganaga to Scottsdale of similar type of activity and issues in relation to it, in performing your report, have you had any reference back to any issues that arose in relation to that construction methodology, which presumably is similar to the one that's about to be undertaken?
The very first one?
Yeah.
No, I haven't. No.
Councillor Harris.
Thank you, Mayor.
On a question.
Yes, a couple of questions. One is, are you able to tell us just how wide the rail corridor is on average when we're talking about this? And then where would the area of crushing of the ballast generally take place within that corridor? I guess there's, to put it simply, there would be the corridor with some edge of road width, if you like, or excluded area which belongs to the Crown, to help provide some barrier against those properties that do abut it.
Consultant planner.
The corridor's variable width. It's probably hard to say what the average might be. 30 metres, maybe. Do you have an idea? Yeah. Yep.
Another question, Councillor Harris.
Yeah, thank you. I think we have a building excluding zone of 50 metres of around a rail corridor within our planning scheme, so I suspect it's probably somewhere between that 30 to 50 metres. Where this work of crushing ballast, as was used up in the North East Rail Recreation Trail between Billycock and Scottsdale, I believe, was imported from New Zealand, where, of course, they have many rail trails. Has there been any examples of them having contamination occurring because they have crushed, because obviously they have a longer time frame, that you might be aware of?
Consultant planner.
I'm not aware of, no.
Okay, thank you. I'll sit on that one for Dick.
Councillor Harris, do you wish to speak to the motion? Or reserve your right at this stage? What would you like to do?
No, look, I will start the ball rolling, I guess. Thank you all, and thank you for the others' questions. This is an interesting development application. It is, in fact, somewhat seen in two parts, but to me it's no different to a development application where we might have a demolition and a building permit to be issued on the same title, or in fact a number of titles, because you might be building a warehouse across multiple titles. So it's not unusual to have us to look at the car park as well as the use of the rail corridor and delegate that to the Dorset Council as the corridor manager. So just first of all, speaking about the car park, we were contacted by the Lilydale District Progress Association on the initial plan, which showed a large area of grass to be turned into asphalt, and they said there'd been no consultation, and so the consultation was then enforced on the corridor manager, that's the Dorset Council, who went and spoke to them, including our staff. They then generally accepted the views of the Lilydale Progress Association and the Dorset Council to no longer take a large area of grass away from the campus, but in fact to simply push the existing barriers out into the grassed area by a few metres, to allow 90-degree parking rather than parallel parking along the spots. During that first meeting, the thought of those who were there, I understand, was to in fact have some of the parking at 45 degrees. And of course, when you have 45-degree parking, there is an angle that it's quite easy to drive into when you're coming up to it. But if you're going the opposite side of the road, it's a very tight angle. You have to turn back on it. I suspect that that is the reason why once that recommendation or thought had been brought back into the council transport area, and the officers made the decision that no, rather than having a 45-degree angle, let's make them all 90 degrees so that people can turn easily into the car parking area. That actually reduces the amount of green space that has to be removed for car parking. So whilst I understand the Lilydale District's Association's thoughts and concerns, they were consulted, but they were not the final decision maker. That is council's role as the decision maker. We have to know the rules. They can have input to what makes sense to them, but ultimately we have the rule book and we must obey by the rule book. Hence, that is why there's been a change perhaps from what had been agreed as what the recommendations from that consultation group to what is now before us, where we've had just, I think, about 6 of the spots, instead of being 45 degrees, they're now 90 degrees, which I actually think is a logical change. I do understand the concern of the residents who fear that because of that there may be some banking up of traffic out on Lilydale Road to turn into the car park to then turn into the 90-degree spots, whereas by sending them all up round the loop to then come back into it at a 45-degree angle, it would be less likely to bank up the traffic. However, I don't believe it will be an issue that we need to seriously consider. And if it is become a problem, then we would perhaps look at putting a turning lane out on the road. But I think that would be a very busy car park. So then that brings us to the second part of the railway being removed, the railway lines and infrastructure being removed under a development application. No, we're not really being removed. That's part of the Corridors Act. It's not something that we're necessarily saying. We know that's the consequence of what we're doing, but we are giving the Dorset Council the ability to operate in our area as the corridor manager, and they will then be crushing the ballast because it's a lot more efficient and cheaper and to crush the ballast. Otherwise, it would involve, as others have suggested, the removal of the ballast and importing new road base to remake your road out of, and that would seem a lot of expense when perhaps it's not needed. And in fact, where it's been done elsewhere in New Zealand, and as I said, I believe it's been done in parts of the North East Rail Trail as well, it hasn't been, it's proved very successful. So I know that Dorset Council have been very pleased with that aspect of it. So for us, it's a simple, relatively simple two-part decision, but it is one decision we must make for both parts. From a personal point of view, the development of rail trails, many people talk about bike riders. It is not just bike riders that use recreation trails. I often ride out to Perth and I'll use the trail that is off-road, and I find runners on it. I find mums with kids on scooters. I find, if I can have a few more minutes.
Well, as long as you stick to matters concerning planning, someone to move said extension. Moved Councillor Mackenzie, seconded Councillor Dawkins. All those in favour raise their hand for an extension. Those against? Councillor Pentridge is against. Everyone else is for. The motion is carried. Councillor Harris, continue, but contain your comments to the planning scheme.
I will. As I was saying, the planning scheme is talking about a recreation trail, and it is not just bike riders. And people do use it for bike riding, and in fact I have ridden the North East Rail Trail myself on a number of occasions and seen many people using it. And it would be a better trail if it came to Lilydale. That would create a better hub and starting point. It would be an even better trail if it finally gets into Launceston and is then continuous from Launceston all the way through to the Billycock Hill just near Ledgerwood. Such things are in fact tourist attractions and do attract people to the rail area. We have seen examples of tourist railways in Tasmania, We have the wonderful on West Coast, the App Rail, but unfortunately it has had to be taken over as a state government asset simply because it cannot make money. And so whilst tourist rail, and I love rail, don't get me wrong, I've been to New Zealand to ride on many trains, but it is not something that necessarily makes sense financially, and particularly if you haven't used the line for the best part of 20 years, you would have a lot of expense to try to get that existing rail infrastructure up to being something that would approach the safety standards required in 2023 compared to the standards that it had some years before. So I do ask you to support this motion, and I look forward to any other further discussion around the table. Thank you.
Thank you, Councillor Harris. Seconder, Councillor Mackenzie.
Thank you. I'd start by saying this is not a simple process, otherwise it would have been done by now. So I don't want to trivialise any of the comments that have been made by anyone. This has been a very divisive journey. There are people who are pro-rail, there are people who are pro-bike riding, and there are people who are pro-nothing. They want to preserve their land for the way it is today. So I think that's in the context of what this is, but I need to keep coming back, and I regularly do this in this council. We're here as a planning authority today to make decisions made under the Land Use Planning Act 1993. That's what we're here for. What we need to also understand is the owner of the land is the state. They own the rail corridor. They have appointed Dorset Council as the rail corridor manager, and the rail corridor manager wants to do something with that corridor, and they put forward an application to make it into a rail trail. So this is not about me disliking rail or whatever it may be. This is actually about a decision that we need to make because we've been asked to make one by the rail corridor manager. We've had a consultant planner who's been grilled quite significantly in relation to a lot of matters here today, who's gone through, so it's not even the council that's making that decision. We've got a consultant planner who's independent of council because of our interest, particularly in the Lilydale Falls car park area, who's given that advice. So it's been something completely independent of council that's given us that advice today. As I say, the contamination issue is the one that probably concerns most of us when we read through the documents that have been coming through. I've ridden the rail trail from Tonganaha through to Scottsdale. Clearly the same issues must have arisen in the same situation. I'm not aware of any contamination issues that have been evident or raised by anybody in the community in relation to that particular area. I may be deaf and not heard it, but the reality is I've not heard any of that. So I would have thought similar things because there's rural land, there's forest, there's all sorts of areas that you ride along through that process, and I've not heard any of those issues. Our consultant planner has given us a strong understanding of how he's interpreted all the contamination issues and what we need to consider in relation to it pursuant to the Land Use Planning Act, and he's given us professional advice. I ain't a planner. I've been doing this thing for 11 years and I'm still learning lots and lots every day that I come out to do this sort of thing. So I'm not across all of these issues. I know he's had to deal with all this very seriously because he had to deal with the representations that have been put forward in regards to many things, and I'm not saying any of those are unreal. I think lots of people are fearing those sorts of things that might or might not happen. But I also look at the topography of the land and the fact that we get a lot of rain out that way as to why all these contaminants that are supposedly coming off trains and things like that haven't washed down into the creeks and contaminated them now. So I appreciate the ballast crushing will have another element that needs to be considered. I'm understanding that that will all be done in accordance with things, and the Dorset Council, who are the rail link manager, need to deal with those things, and that'll be done under the permit that they need to do to ensure that that is all done in the correct manner. So dealing with the actual rail trail thing, I've come to the conclusion that this has been done exhaustively. They've had appeal after appeal through, I think the MLCs have dealt with it, the state government have dealt with it, there's been through the planning tribunals, all sorts of places, and it still comes back to where we are today, that the rail trail has been put forward as something that's to be approved. So therefore, I'm of a view to do that aspect of it in relation to the other part, because you really don't need a car park if you don't actually have the first bit. So therefore, that's why the two need to be together, is that the car park is really an issue that comes as a product of actually having the rail trail from Waina to Lilydale Falls. I've been very involved in the LDPA and Lilydale in general in making sure that we get a good consultation process that went on, which is why the matter was withdrawn in the previous council and brought back today. There was a consultation process with LDPA and with the Dorset Council on site out at the Lilydale Falls. There may have been a couple of small minor decisions, but fundamentally where the car park started and where it ended up actually got pretty much back to where the LDPA wished it to be. There are some minor engineering issues, as I understand it, that are really the things which are for amended plans for discussion. And in my view, because they haven't been amended yet, I guess if the LDPA want to put something towards our council for them to consider again before it's finalised, then I think there's an opportunity for them to do that. I think they have been consulted. Maybe the closing of the loop's not quite the way they would have liked it to have been, but they certainly have, and I think that's a really great step from this council to be more engaged in the community engagement process, and I hope to see more of that going forward. But given that I think substantively what is being proposed in the car park area is roughly what Lilydale Progress Association were pushing for, which was actually not removing the green space, not removing trees, largely that's been achieved. So I don't need to say any more other than say I'll be supporting the motion.
Thank you, Seconder Councillor McKenzie. Any other contributions around the table? Councillor Kai.
I won't be supporting this motion. This DA is another example of how the public will feel that this council is putting development before the health and safety of the people within the community and not considering how this will affect the residents, livestock and wildlife within the area. So from what we've heard today, I'm actually quite concerned. So we as a council should actually do our jobs to not make the public feel as though that they are too small or too insignificant to be heard. And this DA development of the railway and vehicle parking area should not include pulling up the existing rail tracks. So from what I've heard, it's actually two separate issues that should be dealt with separately. I don't believe in putting it all together and making everyone vote as one. Okay, so like I said, from what I've heard today, there's a lot of reasons to not approve this. However, I do understand that it needs to be refused on the basis of the planning scheme. So in the planning scheme, I've found that there's two areas that I feel this DA does not meet. One is the misclarification of the land use. So this is not a passive recreation use class. The description for passive recreation use is for land for informal leisure and recreation activities principally conducted in the open. So for examples includes, this is just out of the book itself, so I can't remember which page it's on, but include public park, gardens and playgrounds and foreshores. And two, this development fails to comply with E9.6.1 P1 because it will unreasonably impact the water qualities of watercourses and contaminations to the land. So, I mean, if it comes up, I do understand through the tribunals that they put a condition on this contamination happening, so therefore it is happening, but I personally don't feel that, you know, a condition is going to really fix the problem. So I'll finish off by saying that this DA should not be approved today as there has not been enough time given to us councillors. So I feel very rushed from the time we got this. Maybe because I'm new, I'm not sure with the new councillors. Maybe the older councillors have been on this subject or this subject for quite a while and I haven't. So I didn't get this till last week and I feel that we really need to take a deeper look, especially with all the additional information that was presented to us today by the speakers. I personally think that this sort of DA in this sort of magnitude should involve more discussions, and they should conduct environmental assessments. That is not just a desktop research, because I looked up on the research that is done by, I think, Pip and Sherry or something, and it was just a desktop research done that I don't think anyone actually went out there and physically actually did a proper research. So I don't know the right terminology, but maybe that needs to be done before we can all make a proper decision. And okay, so I just urge my fellow councillors to either refuse this DA as it is or amend the DA by taking out the removal of the existing rail tracks. So personally, it should be kept separate so that we can decide on one or the other, because they're both quite significant issues, and I just think it's too much to combine it as one and make us vote or decide to vote either for or against on both the issues that is quite significant. So either separate it, or I think we should just refuse it until next time when we have more information, more discussion, more research, because this is quite yeah, it's quite a lot to take in. And I think, as we've heard, I think we had 12 residents people who made the time and effort to come in and speak to us. And it means, I think that means a lot. So, I would refuse. I mean, I don't know how to say it, sorry.
Thanks, Councillor Kai. Councillor Pentridge. Councillor Pentridge.
Look, what I'm concerned about, and from what I understand, a lot of this is a planning matter, and what I've heard over a long period of time, one of the objections has been our yellow-bellied parrot or orange-bellied parrot. We've had species that have been endangered, and it's been an important bit. Now, today we talked about the freshwater crayfish. And I'm struggling to understand why the freshwater crayfish in its natural habitat isn't that important, yet when one finds its way into the tamer, it becomes very important. I was just wondering if someone could explain that to me.
So, Councillor Pentridge, not that we compare one site with another, but specifically could we talk about the status of the endangered species listed and previously spoken of? Catherine, are you able to provide an answer to that question with regard to the status of the species that Councillor Pentridge referred to?
So the giant freshwater crayfish is listed under state and federal legislation as vulnerable species. That brings into play different requirements depending on which piece of legislation you're looking at. So whether you're looking at the Threatened Species Protection Act or the EPBC Act at the Commonwealth level, there are different requirements. EPBC Act looks at habitat for that particular species. The Threatened Species Protection Act looks at the taking of individuals within that population. So if the construction of a bridge was to take out actual giant freshwater crayfish, then you would need a permit to take under the state legislation. So that's how those work.
Thank you. Any further questions, Councillor Pentridge?
I didn't quite, it's still not fully explained. Freshwater crayfish is a natural habitat of that area. And once we lose these things, my understanding is that we'll lose them forever. There has been a fair bit of importance placed on finding one of these crayfish in our river. And it was mentioned and used to support certain things. And I'm still a bit confused why the crayfish in the tamer is very important. Yet the one when we're messing around with its habitat, it comes under some different sort of legislation, and let's just do whatever we have to do. Thank you.
I'm sorry that you're confused. We'll ask Catherine, who might be able to clarify again and assist you with that.
So the giant freshwater crayfish is not known in the tamer catchment. There's a translocated population in the St Patrick's River that were put there by people who like to fish for them. There are multiple freshwater crayfish species, so it's possible that you may be confusing the burrowing crayfish that are found in the West Tamer swamp forests, and they're a different species to the giant freshwater crayfish, which is found up in the Piper's catchment.
Thanks for that. Councillor Pentridge, I have you listed next to speak. Would you like to speak at this point? Councillor Raze.
Thank you, Mayor. I have been reflecting on our discussion today, and I found it really hard listening to our local residents and also the councillor concern about the main issue about environmental contamination in a variety of things. I feel concerned about it too. In ideal world, probably it will be better if we could leave the track there and build our bike tracks along it. And the width is enough, at least 30 meters. But I would like, and I'm hoping that whatever decision we make, that they will take the concern of all councillors and the community about how we should reduce the risk to minimum regarding environmental contamination. But I like to look at other issue we haven't been thinking, which is relevant regarding bike tracks. My vision of Launceston actually how to promote healthy, happy, and active communities. We don't realize how the northeast of Tasmania and Launceston, part of it, they have got one of the highest rates, not just Tasmania, but Australia, of chronic health problems. We have got the highest rate of overweight and obesity, high blood pressure. In addition to that, 3/4 of our population, actually, they are less physically active. They not perform activity enough. Now, having bike tracks, it's an ideal way to promote activities. It's for all ages. It wasn't that like a few weeks ago, one of my colleagues stopped me and she said to me, I have 2 children and they love bike riding, but they can't find actually places in Launceston to go riding, for a long distance.
Councillor Razay, I'm going to stop you there and ask you to get to the planning points.
And the same thing with the elderly, because the major concern is safety. And I feel having bike tracks like this one will provide like a safe environment for people to walk and cycle. Thank you.
Thanks, Councillor Dr. Razay. Are there any other contributions from around the table? Question, Councillor Walker.
Yes, I have many questions. Thank you, Chair. If I just stick, if I may, via you with our planning officer. You are also the planning officer for Dorset Council for their application for their section of the line.
That's correct. And
you were also due to represent them in TASCAT when an appeal was put against them, but you didn't do that.
That's correct. I was unavailable.
Wasn't a part of that?
I wasn't unavailable.
Was unavailable, correct. Yeah. These issues were tested in there, but there is, considerable concern by representatives both then and now that really we still haven't really tested the issues of contamination because they were sidestepped in that process. Would that be a fair assessment of what happened?
Consultant Planner Ashley.
I wouldn't say they weren't sidestepped. There was the whole appeal at the end that was heard ultimately was about the contamination issue. That was the sole ground of appeal in the end, and it was the risk of contamination, the release of contaminants into watercourses under the Water Quality Code. So that was the basis of the appeal, and there was evidence presented by on behalf of the appellant by environmental scientists who did their testing of the issue for the appellant and also for Dorset Council as well, and that was all tested and heard and examined at the tribunal extensively.
Thanks, Ashley. Councillor Walker.
Thank you, Mayor. But in the end, through you, Mayor, if I may, it came down to whether the crushing of ballast was deemed an action that could be seen as something that could be assessed under the Act. Is that correct?
Consultant Planner.
Well, it was similar, not the same, but a similar water quality code to councils in the interim scheme, because that's still applicable. So it was considered. It's relevant for consideration because it works within the relevant distance from watercourses. Yeah, I think the distances are different, but it's yeah.
Okay.
Thank you, Councillor Walker.
Thank you, Mayor. I might ask if I could some questions of either our CEO or our General Manager, if I may. General Manager of Infrastructure, that would be, I imagine, but I'll find out, no doubt. The status of the Lilydale Falls area, people do camp there. It is a public park, I suppose you'd say. It's owned wholly by the council. And to address Councillor Mackenzie, if I may, through you, Chair, It is not just the state government ownership that we're talking about, we're also talking about Launceston Council ownership. And my question too is, as a General Manager or the CEO, is the status of that falls area in terms of its zoning, people's ability to camp there, which they do, present use, and how that impacts this decision.
General Manager Eberhardt, perhaps just the zoning. We probably don't need to go further than that as planning consideration. General Manager Eberhardt, are you happy to answer that?
I don't actually know what the zoning is, but Ashley probably can answer that off the top of his head.
For which property? It's utility?
The Falls.
The Falls is open space.
So, obviously it's public land owned and operated by the City of Launceston for the purposes of recreation and natural value management.
Mm-hmm.
Councillor Walker.
And at present we have some facilities there. We have a dilapidated, I might say, toilet block, much to our embarrassment. Perhaps it could do with some renewal, but we don't have any other facilities there, lighting, something like maybe a bicycle wash if people were going to ride bikes from there, other associated types of infrastructure you might want to have if you were to be developing the area. Is there any plans in this DA for those particular types of infrastructure to be included?
Consultant, well, let's answer it in two parts. Infrastructure that's currently there. General Manager Eberhard.
Well, you're correct, there's toilets, there's also the walking trail in the car park. In terms of the DA, it's as proposed, which is the modification of the car park.
Thank you.
But it's the modification of the car park for a specific purpose. I mean, we own many reserves. We're not going around proposing that we improve the car parks of all those reserves. It's this particular one for this particular reason. And part of the DA, as you know, is the removal of the tracks and the...
Next question, Councillor Walker.
Being that, well, with all due respect, that answer that the DA is simply for a car park is, I would, challenge it's not. It's for a car park and a further use of that facility and that space, not just, improving a car park for no particular purpose.
And so the question is?
The question remains, is there any other associated infrastructure that's going to be included as a part of this increased use of this area, apart from a car park?
Consultant Planner Ashley, with regard to any further stages of development?
There's nothing else included in the application, no. So the application was for the rail trail, and then it was for the car park, which is associated with the rail trail.
Thank you.
Thank you very much. And
I might just ask General Manager Eberhardt to further add to that, if that's okay.
Oh, thank you. Yeah.
Just to be clear, I guess Dorset Council, the proponent for the development. We've provided consent for them to submit a development application. In terms of if you're suggesting that there might need to be investment in toilets or other facilities, obviously quite likely, if it's highly utilised, most likely that's the case, and that will be a decision for the City of Launceston.
Thanks, General Manager
Certainly,
Eberhard.
also an expense for the City
Councillor
of Launceston.
Walker,
Thank
any
you.
further questions?
Chair.
Could we just try not to engage in too much dialogue when people provide the answers, if that's okay?
Yes, further questions, if I may. Thank you, Chair. Have we, as a part of that, surveyed landowners in the area, both for the rail line to be trail and the Lilydale Falls area? We've all heard the interaction that we've had with the Lilydale District Progress Association, but I'm talking about the large number of landowners along the line, I suppose, from Waiina back to Lilydale Falls, as well as other landowners in the area and the users of the area.
Thanks, Councillor Walker. Consultant Planner Ashley.
Being a discretionary planning application, it was required that public notification was required, and part of that notification involves sending a notice in the mail to all the adjoining landowners along the alignment of the corridor, and also other land involved. So the Lilydale Falls Reserve property as well.
Thank you. Councillor Walker, any further questions?
Further questions, if I may. Thank you, Mayor. And the results of that consultation, where are they?
That's what's in the so as a result of that, there was the representations which are made. So the representations are attached to the agenda item and summarised in the agenda report as well.
Thank you.
Thank you, if I may. Thank you, Chair. I suppose I'm saying that as a discretionary decision, it would be normal for council, to seek that feedback and to include that in its deliberations, not just merely through representations, but through community consultation, which was, of course, done with the Lilydale Association. But in this case, because we're seeking how we're going to use council land especially, that there would be a reasonable expectation, perhaps not a legislation, that consultation is included in the report. Is it included in the report?
Consultant Planner Ashley.
Well, the report provides a summary of the consultation process as required by the Land Use Planning and Approvals Act. So I think you might be talking about broader consultation, which is not part of the planning process.
Thank you. So, in other words, it's not in the report, and yet in front of me I have...
Hold on, just to be clear, the consultant planner said that the 34 representations are contained within the report. And
they are contained in the report.
And the summary table is included.
And I hope everyone has read those, and they are relevant to this discussion. What I'm saying is, normally the council provides a consultation process and indeed, as I was about to quote from our approved council flowchart for assessing unsolicited proposals, which this is on council land, to develop on council-owned property, does have within it a step where community engagement is undertaken and a report prepared. So I would like to know where that report is. Thank you, Chair.
CEO.
The crux of this matter is that delegation is provided to the CEO to be able to provide consent for an application, development application lodged to council. So that consent was provided with under the direction of the majority of the councillors. Clearly, it wasn't unanimous in terms of delivering that decision, but that occurred. And so the fact remains that the development application had the consent of this council to be lodged, and therefore the matters in terms of how that was determined is largely irrelevant. It was lawfully given, and we've got an application before us, and we're now beholden to assess that application.
Thank you, CEO. Any further questions?
Thank you, Chair. If I may, it was lawfully given. Indeed, under LUPA, you do have that delegation. I think section 51, if I'm correct. And yet, nonetheless, you did engage in a process where you did assess the...
Councillor Walker, the question,
please.
Question,
certainly.
Yep.
Question is, then why did you engage in a process of assessing the councillor's response to whether we give landowner consent or not?
CEO, notwithstanding that the question is almost irrelevant, given that the process has been explained, but just to provide a response?
No, I would go to the extent that it is an irrelevant consideration, and to consider these matters that occurred at this point now aren't considerable in terms of the decision that you have to make today. So to reiterate, the consent was lawfully provided at the direction of the majority of the councillors. In terms of the process that happened in determining that consent, it is an irrelevant matter in terms of determining the development application which is before council today.
Councillor Walker, any further questions?
Thank you, Chair, if I may. The consent was provided, but yet in 2018 the council had a stated position, which was that we would prefer, and indeed authorised by our CEO, that the council have a preferred position, which is communicated to Dorset Council, that we would like to see the section between Lilydale and, Lilydale proper actually, and Waiina to be a dual type carriageway where we could facilitate both. And it was also considered that we were not in favour of the removal of the railway tracks. So in that consideration, that was accepted and it hasn't been rescinded by this council, why then was permission given for landowner consent to do these, to develop this site?
So, Councillor Walker, notwithstanding that, of course, that
is irrelevant to the planning decision.
Correct.
Well, and
do you have another question?
Yes, certainly I do. I suppose, you know, I've gone through the consultation both internally and externally, which is normally something that we would do. But we also have the case, and other councillors have expressed this, that they are not familiar with this at all, and we have not had an opportunity to even discuss this in a workshop or any other place with the most recent councillors, and we're not referring to them as new councillors anymore. They are certainly part of, you know, a collegiate team. But nonetheless, without that information, would it not be appropriate to defer this matter until such time as councillors have an opportunity to understand all of the issues and more that have been discussed today?
So, first of all, Councillor Walker, it is not normal for us to workshop planning considerations. I also draw your attention to the deemed approval date, the 24th of the 2nd, 2023, contained on page 20 of this DA.
But certainly we can...
Are there any other questions?
Certainly we can seek the consent of the applicant to do that, Mayor. So I'm asking whether that would be, whether the CEO believes it may be appropriate, considering all the nuanced points that have been brought up today, that we seek.
Thank you, Councillor Walker. CEO, do you think it's appropriate?
Well, I can ask.
The CEO is happy to ask someone to seek that we take a break, lay this matter on the table in order for the CEO to seek that extension. It's moved. Councillor Walker. Someone to second it. Councillor Pentridge. All those councillors in favour raise their hand. Deputy Mayor Garwood. Councillor Walker. Councillor Pentridge. Councillor Kai. Councillor McMahon and Councillor Dr Raze. Those against raise their hand. The following are against: Councillor Gibson, Councillor Dawkins, Councillor Palmer, Councillor Harris and Councillor McKenzie. So what's that? 5, 6. That is carried. Just double check my numbers there. Okay, those who are in favour, please, of laying the matter on the table in order for that extension to be sought. 1, 2, 3, 4, 5, 6. Those against. 1, 2, 3, 4, 5. That is carried. We will take a break until 3:15 and go from there.
Okay. No.
Okay, councillors, thank you. We will resume the meeting at 3:15. Previous to the break, we had a motion that the item lay on the table. I'm now seeking a mover that the item return to the table. This is item 10.1. It's moved Councillor Mackenzie, seconded Councillor Palmer, that the item 10.1 return to the table. All those in favour raise their hand. Those against? Correct. So we'll take the motion again. Those in favour of bringing 10.1 back into view? Those against? That is all councillors present. The motion is carried. CEO, you were asked to seek clarity around the opportunity for an extension.
Thanks, Mayor. So, no, we managed to speak with the applicants and they've advised that they do not wish to grant the council a further extension of time to determine the application.
Thank you, CEO. So, at the moment, Councillor Harris, the mover, Councillor Mackenzie, Councillors Dr. Raze and Kai have spoken regarding the motion. Are there any other contributions? Councillor Dawkins.
Thank you. I have been at various tables since 2016 debating this motion, and it has been a movable feast in that time. Something that started as a general trend towards experiential tourism and active transport has turned into something that has created enormous community discord, and understandable. People are concerned about the quiet enjoyment of their properties in a way that they want to continue to use their properties the way that they always have. But as a part of our planning consideration today, we have to look at the points at hand. We understand that reluctantly supporting this and upsetting the people who feel their lives will be jeopardised by this development is something that we take very seriously. It's a very difficult decision to make, but as I say, it has been a movable feast over the years. And the issue of contamination is one that, whilst raised, did not have the import that it has in today's debate. Astacopsis gouldi is a vulnerable species and should be considered. But I would hazard to suggest that other activities have a far greater impact on the future of this species than the approval of this DA today. I have always supported it in the past. I will support the amended or the redrawn car park and the rail trail provision before us today, because it does comply with the planning scheme. Yes, there are discretions, and yes, there are many, but we have debated difficult planning decisions in the past and found a pathway through. And I believe that the consultant planner has been able to demonstrate today that there is a pathway through this for our communities, and to be able to approve this today, as I said, reluctantly considering the outpouring from the community, but with confidence that this is the right thing to do.
Thank you, Councillor Dawkins. Councillor McMahon.
I think the fact that quite a few of us around the table haven't been here for that 5 years of discussion, it's been a very difficult decision for us to come to today. Obviously, we've had lots of representations from people out that way towards Lilydale, and it's always hard, I know for myself, to make decisions under the planning scheme, not wanting to upset people, not wanting to, make the wrong decision. I thank Councillor Dawkins for her take on what has happened previously, because I feel that quite a few of us didn't really understand what has come before now. So I look forward to us making a decision today.
Thank you, Councillor McMahon. A question, Councillor Kai.
When Dr. Raze mentioned about the that the railway is wide enough for, I was just wondering, most of the problems seems to be about removing the tracks. I was just wondering, is it possible to amend this DA to not remove the tracks? Just a question.
CO, consultant planner.
Well, that's a fundamental part of the application, so it'd be a significant change to the application. It's proposed to use the former, the rail formation. That's the very nature of the application, and the tracks and the removal of the tracks is part of that. So no, it'd be too significant a change to the application to do that.
Thank you, consultant planner. Councillor Kai, any other questions at this point? No, that's fine. Totally fine.
I was thinking by not removing the tracks, it would actually, all those people sitting out there wouldn't be worried, and we wouldn't, even though you say there is no risk.
Sorry.
Sorry.
So I need you either to have those thoughts in your head and then come to another question. Yeah.
Okay. No, not at the moment. Thank you.
Okay, thank you. Are there any other questions or contributions at this time? A question from Councillor Harris.
Thank you. Through you, Mr. Mayor, this has obviously been in front of the tribunal, where the planner or the person who wrote us the letter, whose name was Rod, and I'm just looking for his name. Who? Rod? I can't find his name. Rod Thorpe? No, it's not Thorpe. I think it's Rod Cooper. Thank you. Rod Cooper was in the tribunal, along with another expert, discussing the effects of managing if you are crushing the ballast, and whether those the effect of it is manageable. And so I'm just trying to understand whether the tribunal found that it is manageable or isn't manageable, because ultimately that, I think, is quite clear to everyone. If the effect of crushing the ballast is manageable on the environment, then we should have no fear of crushing that ballast.
Thanks for the question, Councillor Harris. Consultant planner.
Yes, so Rod Cooper was one of the environmental scientists. He gave evidence for the appellant, and the Dorset Council had an environmental scientist too, which is the author of the Pitt and Sherry report that accompanies the planning application. So they did, as I said earlier, they did extensive testing at various parts along the corridor, and that was presented to the tribunal. They were both cross-examined, if you like, so they were both asked questions on their evidence, and that informed the tribunal's deliberation, and the outcome of the appeal was the inclusion was the confirmation of the approval, but with additional conditions, and that those two conditions. There's one requiring the contamination risk assessment and the construction environmental management plan, taking account of that risk assessment, and stormwater drainage design. So those conditions were the outcome of the tribunal's consideration and the evidence given by those experts.
Thanks, Consultant Planner. Subsequent question, Councillor Harris.
So they formulated a plan to accommodate it, and are those conditions in this DA as well?
The conditions are those conditions are reflected in this recommendation.
Councillor Walker, question.
Question, thank you, Mayor. So we did get a reply from Dorset Council, but in 2018, when we asked Dorset whether they would consider, seeking an alternative that would facilitate both, did we get a reply from Dorset Council? And what was that reply?
In summary, it was no.
Yeah. Okay, and yet it's still our stated position. I suppose, how does that resolve with the CEO's action, which has been to grant landowner consent? I suppose what I'm asking is, we have a position as a council, which is, as some people have even suggested, why isn't there the opportunity for both, which was obviously council's position as well, and yet it would appear that granting landowners consent sort of flies in the face of that stated position. And I can understand if you say, well, that's not really relevant to the planning decision today, but of course, as landowners, as we are, I believe that it is relevant, because although permission may have been granted, it goes against council stated policy or position.
So, Councillor Walker, the answer to the question is the same, that that's your view, that the delegation of powers allow for it, it happened, and here we are. CEO?
I would like to clarify that the councillors went through a process at the time and provided me with direction to issue consent. So the exercise of delegation was done under the direction of the council, which is just something that I think needed to be clarified.
Another question, Councillor Walker?
Yes, it would be to the CEO directly then, if you feel that needs to be clarified.
No, through me, Councillor Walker.
Through you.
Thank you.
Thank you, Chair. Directly through you to the CEO.
To me, and I'll decide where it goes. Ask the question.
Then if the CEO thinks that it is relevant to mention that councillors were given an opportunity to provide input, it would seem as though that process wasn't followed correctly, procedurally. It was corrupted for whatever reason, and I'm happy to discuss that further if the CEO feels it is relevant to mention that councillors were consulted.
CEO, further comment on the process?
No, look, it is an irrelevant consideration for the matter at hand. It's clear. I just felt that you weren't representing the actual the reality of what happened, and so I just wanted to clearly state that.
Mm-hmm. Thank you, Mayor. If I may, further questions. Of course, our planner acted for Dorset as well as is now acting for us in the assessment process. If we were to reject this application today and there was an appeal, who would the planner represent in that scenario? And indeed, who would we be, or vice versa, if we approve this today and there's an appeal against it, are we then defending Dorset's position, or we're defending our own position, but Dorset becomes the second responder. Is that how it would work?
CEO, question on the process. Richard, are you happy to answer that? Manager of Planning, Richard.
If council were to refuse the development today, Ashley's view is that this should be approved, and so we would be acting contrary to the recommendation. So we would seek an alternative. If we could find an alternative, we would find an alternative expert to support council's decision. If it's approved and it goes to an appeal, we would seek appropriate experts to justify council's decision, and that would most likely be Ashley, given that he's presented the report to the council. Dorset, as the applicant, would have to find their own supporting evidence, and they have town planners, and their town planners have made the application documents to council so they could support them at the appeal. Does that make sense?
Thanks, General
Point of order.
Manager of Planning. Councillor Dawkins.
I'm not sure if this is appropriate, but I can't sit with the word corrupted in the minutes. I'm just really sorry. Some things the latitude I understand, but I think that word's been used with very particular political point, and I'm incredibly uncomfortable about it.
Councillor Walker, would you consider removing that statement?
I'm incredibly uncomfortable about the process that took place where my input was not included. If you wish to have a discussion about that, I'm more than happy to, and for people to decide whether the process was corrupted or not. I wasn't accusing anyone of corruption. I was talking about the process.
You won't withdraw the comment, that's fine. Continue.
The process being corrupted.
Yep.
They're very different.
Do you have another question, Councillor Walker?
I do, thank you, Chair. There are small parcels or other titles. There's 3 or 4 parcels of land that weren't part of the corridor. Is that correct? Are they the road crossings that were part of our land, or are they actually parts that were attached to other privately held land?
Consultant Planner Ashley.
Can you just clarify? Sorry. What?
Oh, in the approval of the rail corridor, I thought that part of that was there was an exception of 3 or 4 parcels that were listed as not part of the Crown corridor.
Thanks, Councillor Walker.
The corridor generally doesn't include road crossings. So the roads that intersect the former rail corridor don't form part of the corridor. I think that's might be what you're referring to.
Thanks, Consultant Planner. Another question, Councillor Walker.
It's been relayed to me that the initial DA that never came before this council was not for both of these parts. It was just for the car park. Is that correct?
Consultant Planner.
No, it's not correct. The application was always for the rail trail with the associated car parking.
Any further questions, Councillor Walker?
Not at this stage, thank you, Chair.
Councillor Palmer, wishing to speak.
Thank you very much, Mayor. After hearing all the people speak today, this is a really difficult decision that we are making. People have spoken for it, people have spoken against it. This week, next week, 6 months' time, I'm not going to be a planner, but we are all here listening to these points of views. Everyone's entitled to that, but we have employed a specialist to represent us, to give us feedback, and we do have to put our faith in that decision. And as hard as this is, after hearing all the wonderful people that have spoken today, I'm definitely urging on the side of voting in favour of the recommendation. Simply that we have an expert sitting here in front of us advising us on all these recommendations, and I think that if we can, we respect everyone's opinion, but we need to sort of come to a decision shortly if we can. Thank you very much.
Thanks, Councillor Palmer. Okay, are there any other contributions? Sure, Councillor Walker.
One of the representatives, Elizabeth Cute, or Cutie, I don't know how her name was saying, was talking about her land being divided in two because I suppose the corridor that goes across it, and while it was dormant or a railway, I suppose her land was always divided into two, but I suppose it's different when it becomes active again, and also that the access and also the manager of that corridor has changed. Would you describe that as her land being divided into two? Is that a fair representation, Planner?
I'm not sure that question's overly relevant.
Well, it's what we're deciding upon today, if I may, Chair.
Well, it would be all parcels of land on either side of the rail that would be divided.
Yeah. Well, that's what I'm asking. Is
Consultant Planner, would you like to provide anything further?
It wasn't already divided.
With regard to that?
Yeah.
No, sorry.
Well, I don't think it's unusual for the corridor to dissect properties, go through properties, and they're divided by the rail line.
And indeed, you heard Miss Cute say that herself. Anything further, Councillor Walker?
I wish to speak. Thank you, Chair.
Great. Over to you.
Thank you, Chair. And thank you for everyone's contributions, especially the representatives. This is not the first time that they've had to come here. It's not the first time they've had to put pen to paper. And it possibly won't be the last time either. I think most people around this table know that. This is not our plan. And yet this is happening on our land. Quite remarkable that we as a council, as councillors, cannot determine what happens on our own land. That's determined by our CEO, who has the power to do that, albeit through some consultation with councillors, but when push comes to shove, it's not our decision. That's problematic, that we no longer have control over our own land. It makes me think that as a council, we do need to take steps in order to re-engage with what it is that we're here for, and that is obviously to represent the community. Now, I'm not saying that other people don't represent the community, but we directly represent the community. And in this case, we have a divided community. We have a divided plan, a plan that's been foisted upon the community. It has its supporters on both sides. We all know that. And there was an eminent solution that would have provided for both. We all live here together. That would have been the way to step forward, but this is not what's transpired. What's transpired is something being foisted upon us, and you all being told that you can do nothing about that if you want to vote as a planning authority. That's what's being recommended to you today. It's not our plan. When it comes to things making sense financially or otherwise, you just have to step out your door to realise that roads don't make sense financially. We pay hundreds of millions of dollars every year to maintain those roads, but for some reason maintaining a rail corridor, if it's going to cost a few dollars, becomes the biggest problem in the world. Have a look how much of your tax dollars go towards maintaining roads, maintaining hospitals, schools, whatever you like. That's a public infrastructure asset, and it should remain so as a public corridor, transport corridor. There's $40 million conservatively of infrastructure that is about to be removed from that corridor. If it was to be replaced, it's estimated that that would be close to $300 million to replace. It's economic vandalism to tear it up. But this is where we find ourselves, seemingly powerless to do anything about it. I won't be supporting that process. I've told the previous Premier that it's economic vandalism. I've told the members for Bass that it's economic vandalism. They don't seem to want to intervene. That's fine. We know that this is a process that has come from the state government. It's been supported by the state government, and this is the result, and we are dutifully fulfilling our part in that process. It hasn't come from this table. It hasn't come from these councillors. We are not in control of our own destiny in that respect. This line for 14 kilometres from Lilydale Falls to Waiina is no longer going to be in our control. It already is not in our control, shall we say. Quite an odd situation where another council has come into this municipality, not only manages an area, but tells us how to manage our own area. Quite remarkable. Quite remarkable that the gentleman from Dorset Council, Rowan Willis, comes in and talks about how wonderfully we've worked together with Launceston Council when they did not respond, or they responded in the negative when we tried to make a suggestion to make it a dual purpose use. Quite remarkable that he comes here and tells us how wonderful we work together when we asked for 2 weeks to consider this further and Dorset Council say no. Quite remarkable. Quite remarkable that their consultation essentially involves speaking to the Lilydale District Association, the Progress Association, which by some accounts represents maybe 10% of Lilydale, and that's it. That's your consultation. And even they weren't satisfied with the result, as we've heard. I have extreme problems of, as you would understand through my questions, about the whole process that we've been through. I fully respect the planner's role in this. This is his profession, this is his job, but it must be difficult having acted for both councils in that process. I understand that's a professional's job, is to do that. You put aside your own experiences, bias, whatever that may be, and do your job professionally. But it creates a convoluted process. An extension, if I may. Thank you, Mayor.
All those in favour raise their hand. Those against? Carried unanimously. Councillor Walker.
The planner in question, and I've spoken at length with Ashley, and I've appreciated his candour and his commitment to this process. But the planner in question, whilst maybe independently selected by Launceston, has also been independently selected by Dorset. And that creates a perception amongst some people that that's a slightly convoluted process and that it perhaps should have been someone else. In another sense, you're the most versed and educated about the whole process, and that's a great thing to have that knowledge and that information here. But it does create also a perception within the community that they're not seeing that independence, and indeed a planner who is defending Launceston Council's position in this scenario. As I said, it's not our plan, and there's 2 DAs here in front of us, but we're being presented them as one, as Councillor Kai suggested, to be able to amend to say, well, that's great, leave the tracks in the ground, that's what we wanted. And I would have thought there would be discretion in the Act for the tracks to be left in the ground and yet the line to still be used as a rail trail until such time. And indeed, that's something that many proponents of the rail have been asking for. Me, myself, I don't care too much for trains or bikes particularly. I have no bias in that respect, but I do see that this is a long-term benefit northeast of Tasmania, which is underserviced as far as infrastructure goes. And we're removing $40 million a track, replacement value of $300 million, and replacing it with something that's worth $1.5 million, and yet that's somehow seen as a progressive step for the northeast of Tasmania to take that asset away, to take that infrastructure away. It'd be like going out and finding a $40 million road and removing it, saying no cars on here anymore. That's essentially what's going on today. I don't support it, as you may have guessed, and I won't be voting today to support this in its present form. I would like to see Launceston's interests represented in this process. I'm not sure how that will occur, but it hasn't occurred today. And I'd ask fellow councillors if they would consider the same. Thank you, Mayor.
Thank you, Councillor Walker. Are there any other contributions? Councillor Pentridge.
Look, listening to my colleagues, I think what I've heard loud and clear, that they respect this gentleman's opinion and believe that he has done his job and done it adequately. But let's keep two things separate. Are we voting to support something because we respect the opinion of a planner, or are we voting for something that we instigated? And I think it's what's been made here very clear. We had very little say in this. This was a decision made for us, yet we'll go down in history as being responsible for it and having approved it, if we go. And I won't be agreeing with it either. Thank you.
Thanks, Councillor Pentridge. Deputy Mayor.
Thank you, Mayor, and thank you to all of the councillors, professionals and the representatives as well. I would like to think of myself as quite a progressional thinker. I would like to continue to develop the city, to increase the economy and the nightlife and everything that we've heard and challenged for, an active community and lively CBD. But for today, for me, with the discretions, I personally, I can't sit with those for today. I love the idea of the rail trail. I love the idea of an active community, but yeah, I won't be supporting it today because I can't sit comfortably with the discretions today.
Thanks, Deputy Mayor. If there are no further questions, Councillor Kai, you've got a question?
Well, question. So how hard is it to amend the DA to not have the tracks removed?
So I think you've been told previously, that's CEO.
Thanks. No, look, it's not lawful. It's too great a change to what was applied for to be able to do it. So it's not something we've got an ability to be able to consider.
No consideration at all? None.
Councillor Pentridge, a question?
In trying to be of some assistance to Susie,
to Councillor
I think
Kai.
it's clear, Councillor, right? I think she needs to be told that part of this from the Dorset Council was to actually cash the rail in to actually pay for
What's
the
the
work
question, Councillor Pentridge?
Well, that's an important, it's an important fact that the rail, or can the rail be left, as a question, can the rail be left to one side, even if it's removed to allow the trail, right? Or in actual fact, is part of what we're agreeing to today is for that rail to be ripped up and sold off to scrap metal, right? Never to be replaced.
Can the rail be
The rail be removed. There's photos that I haven't got with me here, but there's huge stockpiles of rail and sleepers in storage for such proposals and future rail lines, where in this particular case, in this particular line, it's already been doomed because it's going to go and be scrapped to put the money into the bike track.
Thank you. Repurposing of the materials, consultant planner.
That will be erected. So sold.
Section 100 subsection.
Just microphone on.
We're just looking in the Strategic Infrastructure Corridors Act here, which is the section which is dealing with the minister's approval. So it's beyond outside the planning process, but it says here. So it's section 100, and then subsection 3. The minister may only dispose of rail infrastructure under subsection 2 if he or she has given notice, published in 2 newspapers circulating generally in Tasmania, specifying his or her intention to dispose of, and inviting any person interested in using the rail infrastructure for the purposes of the operation in Tasmania of a railway to apply within 4 weeks of the date on which the notice is published under this subsection, to have the Minister dispose of the rail infrastructure to the person. So it's giving an opportunity for someone to make a submission to obtain the rail infrastructure if it's for railway purposes.
Great, thank you. Further questions? Councillor Harris, do you wish to close?
It's been a long discussion, and I thank everyone for their comments. I won't address all of them, but I guess it is clear to say that this is a development application on land that is owned by the state government for a rail that is currently a rail corridor. And any selling of the rail is not what we're deciding today. That'll be decided by the Minister, so thank you for that. We also have, it's clear that we have an expert planner to help us make this decision. You pay an expert because they are the expert, we are not. I don't think any of us have a planning background, but we should listen to what they tell us. We should listen to the information he has told us about what has been put before the tribunal and found to be fact, that you can manage any issue as far as the crushing of the ballast and the effect on the local environment. Just because someone said it doesn't make it true. Facebook's like that. Just because it's there, you read it on Facebook, it's not necessarily true. Yes, there will be changes to people's environments because there now will be a corridor that people will choose to walk or ride through, which currently they are excluded because you're not allowed to walk or ride on a train track. So there will be changes. And where this has happened elsewhere in the world, it has introduced new tourism opportunities at the Lilydale end and even on some farmers' side fences. Because to say that people are going to steal their stock is quite frankly preposterous. If you think you can ride a bike with a sheep across your shoulders, good luck. But why don't you just take it from the road and throw it in the back of the ute? Because one assumes if he fronts on the rail trail, he also has a road frontage. So the reality is we have today a decision that says one DA. That is to use the 14 kilometres as an active recreation zone instead of a rail line. And the second part of that is, because we've got that, we'd like to make some changes to your car park. And those changes have been discussed with the community, they have modified from the original proposal, and now they are relatively minor changes to the car park, which will allow cars to park there. Yes, the people have had to's and fro's about the process, but this is where we're at. And we should never lose sight of that this is about approving the development application. After this, it's planning appeals if they want to.
Thanks, Councillor Harris. We'll put the motion to the vote. All those in favour raise their hand. Those against? Deputy Mayor, Councillor Walker, Councillor Pentridge and Councillor Kai. The motion is carried. Item 10.2 has been withdrawn from today's agenda. Therefore, Council no longer sits as a planning authority, and we move to page 55 of the agenda, item 11.1, as Councillor Walker exits the chamber. I draw your attention to a couple of items, specifically Saturday the 18th of February and the fabulous Monofoma Festival that Launceston has enjoyed over the weekend just gone. It was an incredible event that really showcased a wonderful part of our city, and I know that the number of interstate and intrastate visitors that I spoke to really enjoyed Monofoma 2023. I also draw your attention to Monday the 20th of February, where I attended and spoke at the Launceston Chin Community National Day, the 75th anniversary of Chin National Day, an incredible opportunity to celebrate the diversity so prevalent and welcomed in our community. Are there any questions with regard to the Mayor's announcements? We move to item 12, Councillors' reports, the opportunity for councillors to provide an update. Councillor Palmer.
Thank you very much, Mayor, and I was honoured to represent yourself at the Lilydale Sub-Branch Annual Luncheon, and I'd like to thank the President, Lindsay Godfrey, and his wonderful committee for welcoming me on your behalf. And also I was seated next to a wonderful man called Brian Harper, OAM, and he does wonderful work with Vietnam veterans and their families, and he volunteers hours upon hours to make sure that those veterans are well looked after and that they are cared for. And he drives a bus, a community bus, and picks people up and takes them to different appointments and things like that. And that is something very close to my heart. My uncle served in Vietnam, so that was a very touching conversation that we had. I was able to have lots of other conversations with some returned servicemen and women. And they are the salt of the earth people. They would do anything for anyone. And I was just really, really blessed to be a part of it and be there with them. Mateship really is a powerful thing. And these people there on Sunday had it all, had bucket loads of it. There was a wonderful guest speaker there. Her name was Amelia. She was the 2020 Frank McDonald recipient. And she spoke beautifully, and it really touched everyone in that room. Also, we had the wonderful Lockie there from the Lilydale District High School, which I actually attended on your behalf as well at the end of 2022 and saw him there. And Lindsay, the President, invited him to be a guest performer there on Sunday. So thank you very much.
Thanks, Councillor Palmer. Councillor Dawkins.
Thank you. Along with Council Officer James McKee, I was invited by the Northern Young Professionals Network to discuss sustainability in business last Thursday night. Knowing that a group like that of young professionals who want to be able to embed the quadruple bottom line in their practices, it was really important. They got to hear about how you think about people, purpose, profit and planet when discussing and considering business decisions. And I think Kirsty Matte today, having her speak about Redress Hub, is just a brilliant example of how a business can be sustainable and be profitable and have a future. So hats off to them. It was a pleasure.
Thank you, Councillor Dawkins. Are there any other councillor reports? Councillor Kai.
Well, I don't know if this is the time for it. On Wednesday the 15th, I attended the Elgates Local Government Review at Longford with Councillor Harris and Councillor Pentich, and there was great discussions and inputs from councillors of the neighbouring council, and I feel like we should do this more often. Yeah, thank you.
Thank you indeed, Councillor Kai. Thank you for the contribution. Any other councillor reports? Let's move to item 13, questions by councillors. Starting with councillors' questions on notice, 13.1.1, deed of agreement. 13.2, councillors' questions without notice. Councillor McMahon.
Thank you, Mayor. The Australian Local Government Association is urging councils to have their say on the federal government's new National Housing and Homelessness Plan. Stakeholder engagement is due to start in the second quarter of this year. Will our council be registering to be a part of this process? And if so, do we have a time frame for when we will be presented with a report in regards to the effect of short-term accommodation? As I feel that will form part of a much bigger conversation around the current housing shortage and what we can do as a council, and potentially form part of the feedback for the National Housing Plan.
Thanks, Councillor McMahon. Two-pronged question, CEO. Are you able to answer?
Thanks, Mr Mayor. So the discussion paper in respect of the impact of short-stay accommodation is listed for the next workshop. So you'll have that information tomorrow to be able to, and obviously that will then, assuming the council gives the direction, that will come to a council meeting to be publicly discussed. So in terms of the contribution or the participation in the the national projects, certainly we can. I'll have to take it on notice in respect of the scheduling of such, but we certainly are able to, and I don't disagree that this paper can certainly form part of our submission.
Thanks, Councillor McMahon. Thank you, CEO. Councillor Kai.
Brian from QV Mag asked when we're going to restart the community engagement to QV Mag by volunteer guides.
So we'll take that on notice. Sorry? Just with regard to the opportunities for guides post-COVID at the QV Mag?
Right.
So we'll take that on notice, and a detailed response will be provided by the General Manager, Shane.
Right, okay, thank you.
Any other councillors' questions without notice? Councillor Pentridge.
Mr Mayor, I seem to have a great deal of difficulty in ever obtaining any information in relationship to matters that have been brought up in council, and we won't bother going into all the others at this point, but I recently talked to Dan Ryan about a report which indicated it was to do with our river and the contamination, and the report that's been quoted was a letter that there was mortality in relationship to the dredging and the fish. Now, I've asked for a copy of that report, and I don't seem to be able to get it. And Dan Ryan feels that I'm a third party. I'm not sure. I suppose I'm asking the question, as an alderman and being asked to make decisions in relationship to the river, both now and in the future, why am I deprived of some of this information?
CEO, a question around the Launceston Flood Authority's reports and access for elected representatives.
Yes, that's certainly the issue. So the information you're seeking is the property of the Launceston Flood Authority. So, and I believe you have already made contact of the chairman to seek that report. So that will now be considered by the LFA, and it's up. We're not able to release it as a council. The Flood Authority have to make the decision to release it. So, and so that's in train, Mayor.
Again, I have got it on good authority from people on the Flood Authority and the previous part that report was not instigated by the Flood Authority. It was instigated by this council and given to the Flood Authority. So when did that then become theirs? When we instigated it and organised it.
CEO, is that something you can answer now?
It is. It's not. That's not the fact. So it was fully funded by the Launceston Flood Authority, and it was provided to the board of the Launceston Flood Authority. I'm on the board of the Local Government Flood Authority, and I'm aware of what happened. So that information that you've said there isn't accurate.
Well, Mr Mayor, I can assure you that the people who told me were on the Flood Authority too. And the second part is we can sort this out real easy by getting a copy, a front page copy of who actually instigated it. It'll be written on the report. So can I have a copy of that front page?
So I think the question, thank you for the question again. You've been directed to the Launceston Flood Authority with regard to making it available. You've heard the CEO say that he's aware as a member of that authority that they're going to consider your request, and we'll go from there.
No, well, I haven't been notified of that yet.
Okay.
So, thank you.
You heard it here first. Any further questions? Councillor Harris.
Thank you, Mayor. Just a question from some residents at St Leonard's who are asking about the residential strategy that we have going forward for the St Leonard's area that is listed to occur in this financial year of 22-23. And the residents are sort of hoping that, A, is it going to happen this year or is it likely to be deferred, which I suspect it is because of the work we've been doing in the South Prospect area as a more urgent one at this stage. And will the residents have opportunity to have input into whatever planning strategy that we put forward for things such as public toilets or pump tracks and various other community facilities?
Councillor Harris, General Manager Ryan, together with Manager Planning Richard, are not here, so we'll take that on notice and provide a detailed response. Are there any additional councillors' questions without notice? Let's move to item 14. 14.1, Transport Committee meeting held on the 25th of January of this year that Council receives the report. Someone to move said recommendation. Thank you, Councillor Harris. A seconder, Councillor McMahon. Councillor Harris, do you wish to speak to the motion?
I'll just briefly say that everything there was basically what was discussed, and in the interest of moving on, I think everyone can read it for themselves. Thank you.
Thank you. 14.1, page 60, Transport Committee meeting. Seconder, Councillor McMahon. Does anyone wish to speak to 14.1, Transport Committee? Councillor Harris, anything further? Let's put the motion to the vote. All those in favour raise their hand. That is all councillors present. The motion is carried. Item 14.2, Tender Review Committee meeting held on the 9th of February. Moved Councillor Mackenzie. A seconder, Councillor Harris. Councillor Mackenzie, do you wish to speak to the motion? Councillor Harris. Any councillor wishing to speak to the motion? We'll put the matter to a vote. All those in favour raise their hand. That is all councillors present. The motion is carried. We move to item 15, 15.1, 2022-23 budget amendments. Council to consider the changes to the statutory estimates, consider adjustments made January 1 to January 23. It's moved, Councillor Mackenzie. A seconder, Councillor Harris. Councillor Mackenzie, do you wish to speak to the motion?
I do, because it's just a little disappointing that we're moving things from capital to operations, particularly in the amount of $1 million. So what that means is that our operating situation will be $1 million worse off. Cash flow, it'll be exactly the same, but it's going to come out of the operations bucket rather than the capital bucket. So that's, sometimes it goes the other way. This one's gone in an adverse thing, which will just affect our result at the end of the year, but it's there, and the reasons are simply that the nature of what we were buying is deemed to be not capital.
Thanks, Councillor Mackenzie. Seconder, Councillor Harris.
Nothing further to add, thank you.
Any councillor wish to speak to the budget amendments? 15.1. I'm on page 64 of the paper agenda. Councillor Mackenzie, do you wish to close? Put the motion to the vote. All those in favour raise their hand. Those against? Councillor Pentridge, would you like to vote? We'll go again. All in favour raise their hand. That is all councillors present. The motion is carried. 15.2 is personal micro mobility or e-scooter trial review and recommendations. I have one speaker listed in Robin Smith. Thank you, Mr. Smith, for bearing with us. Just behind the microphone, and if you...
how long do I have, please, Mr. Mayor?
No extension.
Yeah.
Over to you.
Is it 3 minutes? Or?
Yes. 2 minutes.
2. Starting. I went to the Mona Firma on a scooter, probably one of the bigger users, but I was also a pedestrian during the period of this trial, and I was run over by a scooter. I received a response from Beam Australia support of Beam. It says, I've suspended the user concerned. We also found that they had been misusing the scooter, doing burnouts and skids. Again, I'm sorry for the injury you suffered during this incident. We try to weed out bad riders as soon as we become aware of them. So thank you for reporting this, and I wish you a swift recovery. That's the last I heard of it. And there are other people that haven't really heard any more having been injured. This report seems a bit light on feedback for something that is for the councillors, and I do speak for this motion, but with some suggestions, that this is an information process. It took a year, and I, other than a few comments that I did mention in a question that I didn't receive a response on, that seemed to be a little bit, how can I be generous in saying, cheesy, I think, are the 7 comments that were made, the only 7 comments from users in the survey. It is somewhat unfortunate that's what you're basing your decisions on. In the motion, the recommendation it does talk not about the tenure of the beam operator, and it does somehow confuse me whether you're talking about the legislation for the use of all scooters, private and under this use, or whether it's just the beam and any other operator going forward. 8.3 signage changes is a concern to me because it reflects hours of 9 a.m. to 5 p.m. that's proposed ban. That does not reflect modern trading hours if you want to control the use of the scooters. That doesn't reflect it, and it does create a conflict. Sometimes you can use them in areas, sometimes you can't. When I read the report, it's confusing because it uses the colour scheme of the operator, which is their corporate colour, purple. Not quite sure why that's so heavily used in the council's report.
If you could just finish up.
Was that 2 minutes, was it?
It goes fast.
It does seem to be light on to me, the feedback that I've heard from people using the...
Thanks, Mr Smith. At 4:08, Councillor Walker returns to the meeting. Before we begin, page 492, General Manager Foster, Sarah McRobbie and Cameron make their way into the room. I wonder, Sarah, if you or Louise are able to answer the question raised on page 492 with regard to the lawfulness of that image contained.
Push the button. Thank you, Mr Mayor. The image is an accurate reflection of a zone in which it's legal to ride those devices. If those devices had turned the corner into Civic Square, the geofencing would have kicked into operation. They would have slowed down to a stop because Civic Square is gazetted mall of council, so they're geo-fenced out of that location. But on the corner where the photo was taken on the footpath, yes, that's a legal place in which they can ride those devices.
The question with regard to the inclusion of genuine feedback obtained during the trial from people who were not scooter riders and the like, feedback provided and how that was used in the report.
So the nature of the report is themed around a number of issues around safety, efficiency, use of the road, risk, those elements. Those themes were taken directly from the significant feedback we received from the community during the course of the trial via written correspondence to council, via engagement with entities such as our Access Committee, some one-on-one conversations with users, and from the user surveys from the providers who participated in the trial. So the whole report is framed around responding to the feedback that we received as a result of our engagement during the course of the trial.
And the validity of the comments made from the suppliers with regard to the positivity experienced by users.
So the comments attributed to users of the devices provided by the Beam and Neuron are legitimate comments from their users as part of their survey experience. Where the providers have been asked to separately comment, that has been specifically identified throughout the report. So there were some elements where we sought their specific feedback, and that has been attributed to them as the operator, but those comments are from users.
Thanks so much for the answers to those questions. Someone to move. Councillor Harris, you're moving the recommendation, and it's seconded by Councillor McKenzie. Councillor Harris, do you wish to speak to the motion?
I will. This recommendation or the motion is that we receive this report and that we accept the following recommendations as laid out there about the clear promotion of roles. And probably that's the most interesting one because really Tas Police have a lot to do with the policing of how a vehicle, a personal mobility device as they're now known, and that can include a scooter but also these single-wheeled devices that are personal mobility devices. And there are minimum ages associated with using such devices in the public realm, which it seems to me that many parents have disregarded and have simply bought their 10-year-old an e-scooter to ride to school. And in fact, I saw one today going to a primary school. So to me, that clearly is in something that needs to be well promoted out there about the age of a legal rider, as well as the 2 and 3 people on one scooter that we see. We see people without helmets. It's the same as people riding motorbikes without helmets, or in fact people on motorbikes riding with 3 or 4 people topped on it as well. It is not legal, and yet people seem to think that because it occurred as part of our trial, that somehow we as council are responsible, and we are not responsible. The introduction of restrictive parking areas is a good suggestion, and one that I've had right from the start, because particularly around the CBD and the exclusion area that the officer talked about, there can be problems with the geofencing based on the mobile telephone network, which will allow sometimes a geofence to be breached. Well, I won't say legally, but it's just that if people try, sometimes the networking will not cut it out. I had exactly that problem when I tried to repark a scooter I hired outside the town hall. I couldn't put it back at the town hall in exactly the same spot. The geofence would not let me. I had to take it across the road to outside the post office. So that is just the problems with the technology. It is not the operator's fault. It's not the council's fault that that occurs. These things do happen. It's like when you have a phone call drop out or something similar. Similarly, as far as the signage changes, I think it's most important that we do upgrade obviously the CBD signage changes to show that they are excluded, so that users will go out there, because of the large number of private scooters that have now been purchased. Having tried the rental, many people have gone and bought them because they're an ideal way for them to get around. So we now need to make sure that those areas are well signposted to say they are excluded from the CBD and other areas that we deem necessary, because the geofencing that occurs on a rental does not occur on a privately owned scooter. They can ride them basically wherever they can. And I guess the expansion of the area to Kings Meadows, we're now down seemingly to one operator, and so it will be interesting to see if that operator does wish to expand to Kings Meadows, and we have been subject to a petition to make sure that they are operating perhaps in the less busy areas, but as a connection from Youngtown through to the city, there has to be some way for a scooter rider to get through the Kings Meadows area, and that's something that we need to be cognizant of when we're looking at excluding people and where they can or can't ride. In much the same way as there was some discussion about whether scooters should ride down St John Street within the exclusion zone on the road rather than on the footpath. But for that, I think we've done about enough. It's been a most interesting process to go through. I certainly believe that the personal mobility devices do provide a very viable transport option for the last mile of people who may come to our city, and whether they park on the outskirts and then scooter in. I think that's an outstanding response, because we cannot continue to park more and more cars in the city. And similarly, it will hopefully enable people who use our bus network the bus might not always take them where they want it to go. It will enable them to easily get there. And of course, some of these devices are quite portable and able to be carried on buses. I'll hopefully get the support of everyone else around the table to accept this report. Thank you.
Thanks, Councillor Harris. A question from Councillor Mackenzie.
Thanks. Just before I speak, and I just want to clarify, today we're receiving the report and the recommendations of it. The trial's concluded. I'm just querying, there's still not an action here as to what we do next. So just querying what that might be as to what our, or if I missed that, I've missed that. So at the moment we're just receiving the report. So I just really want to say, A, what's happening with scooters today, and B, what's the next phase if we accept this today, what's the next phase in the program?
General Manager Louise, expansion upon point 2, accepting the following recommendations.
Thank you, Mr Mayor. Councillor Mackenzie, if the recommendations as they stand were adopted by Council, yes, you received the report. As part of that, you're accepting the recommendations as outlined as part of the report, and we will seek to implement those recommendations. So the scooters that you see on the streets will continue under their current operating guidelines, and we will engage with the operator to negotiate a new agreement based on the parameters established as part of the recommendations.
Councillor Mackenzie, do you wish to speak?
Yeah, look, I stand to support the recommendations that have been put. I personally think that the PMDs, they've had their issues as we've known, and there have been issues which have been raised and have been recognised in the report as well, and some of the issues that we've needed to deal with through that process. To me, I see it's just like a bike, and bikes are just as important in relation to the whole scheme of things. But I think that as we go into the next century, the mobility in and around the city, I think, yes, we have issues on our footpaths and things like that, but I know we're well aware of the issues that have been raised, which are in the recommendation, so I'm very comfortable that the majority of those have been sought out, and I guess as they come out, we're just, I think, putting in place how we deal with issues going forward is another one of the recommendations as well. So I see this as the evolvement of our city. I see this as a way of actually de-trafficking maybe for cars, and maybe it becomes for people, push bikes and PMDs. And so that's something that I think is going to be very good. And I think the ability for people to hopefully get our other broader transport network in place, which is our buses coming in, people will see the need not to bring their cars, but catch a bus or some other portable device, and then they can do their things within the city boundaries on their PMDs, their feet, or their bikes. I guess the only other thing was just hopefully just expanding out the thought process just for electric bikes as well, and seeing whether they're something, I think they are being used in other jurisdictions, so just a consideration just in the broader concept of doing this, but otherwise I think a really good report.
Thanks. Councillor Mackenzie, do you wish to ask about specifically bikes?
I've just asked for it to be considered.
Considered. Noted. Councillor Dawkins.
Thank you. As the chair of the Access Committee, this was obviously brought to us a number of times as it's something that was of real importance to people, especially the community representatives on that committee. I hope now that this report's been received that they won't be forgotten, because of course a big change like this was a really big change to people who have mobility issues, and it will be really interesting to see as the months and years go by whether this is something that becomes accepted or whether there'll always be a lot of questions around that table about how people with differing abilities have been considered. In general, I think that the idea of foregone carbon emissions is obviously something that is somebody interested in sustainability and a council interested in sustainability that we need to keep moving through. And the equity in transport options, obviously, it's been spelled out that this gives more people more opportunities to get where they need to go at a reasonable price, and undisputed that that's something that people have to consider during this cost of living crisis. I don't know if anyone's been following the debate around the 15 or 20-minute cities, but there's been some really interesting conversations, including a council which was going to debate that very thing, which is essentially how you can live in a city where you don't have to move more than 15 or 20 minutes to get where you need to go using this kind of sustainable transport. Recently, a council on the mainland was actually blockaded by people who were objecting to that, because they were concerned that their liberties were being stymied. So there's so much to the debate around transport and the debate around how we live in our cities, and this is just one step along a path, I hope, to a more sustainable community.
Thanks, Councillor Dawkins. Any other contributions? Councillor Dr. Raze.
Thank you. It's wonderful to see that people are using this, and the making in your report how it showed that more than 50% have reduced the use of their cars, which is wonderful. There is a concern, as the Councillor has mentioned, about the age, and I feel that it's so important to provide education or information. But what's the best way to do it, whether when they buy the scooter, whether they will have like a information list about the age, about speed, where to, make them aware about their restricted area to that. My second point I want to raise will be, what about as if there will be massive expansion, let's hope, with the use of it, how can we maintain that about getting reported accidents in the future, because that will be important, especially as it's early stages of the use of it. Thank you.
Thank you, Councillor Dr. Raze. Question, Louise, with regard to, I guess, permit into the future and what can be incorporated there with regard to reporting.
Thank you, Mr. Mayor. It's certainly a condition of permit that would seek to include as part of our negotiations. The operators that we've dealt with so far are quite open to sharing that information. We've also will continue to have conversations at a state and potentially federal level about consolidated accident statistics so that there is directly comparable data.
Thank you, General Manager Louise. Councillor Walker.
Thank you, Mayor. And yeah, I certainly will be supporting this report, and I think it does contain most of the elements that have been previously talked about by councillors in workshops, and certainly, you know, the experience that we've had over the period of this trial. Included in there is a, if not a request, then a desire for us to get feedback from the state government, from medical facilities in terms of reporting, so that is contained in there. But what is not contained, and is one thing I continue to advocate for, is more clarity around those built-up areas. I know it's addressed somewhat in terms of what the petition regarding Kings Meadows refers to, and I know it's referred to in a sense in terms of, you know, continuous clarification of roles and road use and things like that. But I think there is a more urgent and pressing matter, and it's not just to do, obviously, with the hire company. It's to do with the personal use. As Councillor Harris refers, this is on the increase. I think that the hire aspect of it, H-I-R-E-R, the hire aspect of it is going to become smaller, and the personal use, the personal ownership of different devices is going to become larger. You know, that happened with skateboards years ago, roller skates or whatever. It's going to happen here with things that we haven't even seen yet. Maybe the hoverboard will be invented, I don't know. But in the meantime, this is where the growth, I expect, and I'm sure a lot of people, other people agree, will be as these things become more affordable. We've got the push bikes and that sort of thing, and they are under similar types of categories. But when it comes to footpaths in commercial areas, they're not always under similar categories as far as I'm aware, and correct me if I'm wrong. Yeah, riding a bike, it depends on the speed limit, I know, but riding a bike is not always in the same category as these devices. Would that be correct? I'm allowed to ask a question. Thank you, Chair.
If I let you just keep...
let me finish. Okay.
Is that okay?
I will leave that as a question for the end. So that is where we need to focus, and how we facilitate that as a council. Of course, that's our role. You know, we build skate parks. We do build bike paths and things like that. There's a role for us here, which is not just, you know, the regulation and the permits and the collecting of fees and things like that, but the facilitation of how they're used, because more and more it'll be out of the hands of the service provider, the person hiring these things out, and it will be in the realm of the public. There'll be second-hand ones, there'll be all sorts of, you know, motorised devices, whether it's electric or otherwise. So having said all that's my concern, that we continue to focus on those built-up areas, and I will just leave with that question, if I may. Thank you, Chair.
Sure. Thanks, Councillor Walker. General Manager.
I'm going to attempt to answer Councillor Walker's question. If I've got it wrong, someone will jump in. In terms of council's ability to engage with areas where they're precluded, like the permit, the recommendation states will seek to amend signage in those areas where they're already prohibited as a result of our bylaw, same areas that are prohibited to bikes under our bylaw. Does that provide enough context to your question?
It does. Is it then a supplementary question, if I may, Chair? Sure. Is it then the same on the roads? Because the bikes can ride on any road, but these devices, I understand, can't.
Thanks, Councillor Walker.
So look, there are differences. For example, a scooter's not permitted in a on-street bike lane, which seems ridiculous. So I think part of our ongoing role is to continue to advocate for harmonisation of legislation, because in other states they are permitted in bike lanes. So I think there's a long way to go, and we've got to continue to advocate with the state more improved safety and more consistency in how it's regulated, as we do now for other forms of transport.
And just another question.
Sure, Councillor Walker.
The response to the petition, I know it's somewhat contained in here, but are we still to do a separate response to that petition? Is that the case?
So, General Manager Louise?
So in terms of meeting our legislative requirement to provide a response within 42 days, we've absolutely closed that loop by advising the petitioners that it would be considered as part of this review. Post Council's decision today, we will write to the petitioners again to tell them the outcomes of today's discussion.
Any further comments or contributions from councillors around the table? So just reiterating that this recommendation has two parts, which I think has been made clear, but just to ensure we're all aware of that. Receiving the report, and we're accepting the following recommendations with regard to scooters into the future in the City of Launceston. Councillor Harris, do you wish to close?
I will briefly, just as an update to say that children under 16 or must be 16 years or older to ride a PMD. However, children under 16 are still permitted to use low-powered e-scooters which do not exceed 200 watts or 10 kilometres per hour. So there is actually the ability, which I wasn't aware of. I knew they were excluded from the rental contract side, but which of course is where we started the focus, because it was all the rental scooters that caused somewhat of the chaos. But from that, people bought their own. So there is a limit of 200 watts and 10 kilometres an hour for children under 16 to legally ride a scooter. But the definition of where to legally ride a scooter is what is being subject to debate, because effectively if there's a dotted line down the middle of the road, you're not allowed to ride a scooter on that road, which prohibits you from using the bike lane on Elfin Road because it's got a dotted line down the middle. So that's the type of law that we need to lobby the state government, because they're the ones who wrote that law to say you can't ride it in the bike lane, to change that law, because we don't control that. We only control certain areas, such as the CBD, the seaport and others. So a great report, and hopefully the people in Kings Meadows will recognise that most of the area they're talking about actually is privately owned land as part of the Meadow Mews, that it will be up to the operator there to make his own decision about whether he allows any e-scooters into that area. The only area we would actually be controlling is the footpath area along the shopping strip, shall I say, on both sides, because again, they can't ride on the road because it has a dotted line down the middle when they get around to painting it. But other than that, I recommend it all to you to approve. Thank you.
Thank you, Councillor Harris. We'll put the motion to the vote. All those in favour raise their hand. That is all councillors present. The motion is carried. Item 16, the CEO's network. 16.1, disposal of portion of the council's own land, 65 to 85 Murphy Street in Invermay. The recommendation that council decides by absolute majority pursuant to section 177 of the Local Government Act to sell 1.635 hectares of the lot comprised in the certificate to Tas Water. The approximate area shown in hatch in the sketch contained within the report. 2, notes the valuation. 3, requests the CEO to do all things and exercise all functions with respect to recommendation 1, with subsequent pieces there. And 4, notes for avoidance of doubt the CEO in term of this matter is the General Manager in the Act. Someone to move? Yes, Councillor Walker.
I'm sure it notes the valuation. It notes the price that it would sell for, but not the valuation.
Point 2 refers to us noting the valuation. Point 3 refers to the contracted sale price.
Thank you.
Someone to move something? Moved. Councillor Harris, you moving the recommendation? Yes? A seconder. Councillor Dawkins. Councillor Harris, do you wish to speak to the motion?
Briefly, so this has been discussed at workshop, I think, from memory, where Tas Water wished to use part of what was some silk ponds on the side of, what is that street? Murphy Street, yes, for potentially where they could do the dredging part. Is that what this is? No, it's not the dredging one. We get too many things there. So this is just an expansion of what they need to do for the actual sewage settling ponds. Thank you.
Yeah, sorry.
Perhaps you might need to correct me on that one.
Yeah, let's
take that as a question, Mayor. I'll just
Yes.
clarify.
Yes.
So what's proposed is to provide a 10 megalitre storage tank on that land, and it was previously proposed under the TERHAP that council would be housing 3 times 3 megalitre storage. So it was going to be in Kings Park on our land, Margaret Street, and in Racecourse Crescent. But the final design has provided a single storage on this land as the preferred outcome. So.
That's right. My apologies for getting confused of which bit of land we were doing with this thing, but as the CEO has said, this is the 10 megalitre storage so that the pumps can pump it there to hold it so the sewerage settling ponds can do their job in the event of large downpours and where we have more water than can be handled initially. So it's an important part of the cleaning up of the Tamer. As such, we're all part of this solution, and it would seem logical to me that the land that would be probably difficult to use otherwise to be sold for $1 to Taswater for their use for the betterment of the city and the river is the best use that we can think of for that particular bit of land. So I'm quite happy to support this particular motion to hand that across to Taswater with the CEO shepherding it through to make sure that all of our interests are in fact being well looked after.
Thanks, Councillor Harris. As the mover, a question from Councillor Mackenzie.
Note that the value is 736,000 or thereabouts in there, and I also note in there that part of the offset is the fact that we might have to spend $20 to $40 million to move contaminated materials to Copping, which I think was mentioned once before today, and so therefore the value of it is therefore questionable. My question really begs itself in relation to the fact that we're contributing to the TERHAP with our $11 million. It's a question of whether we're going to get a $735,000 benefit out of what our contribution towards that, whether that's possible that that's concluded in that. And secondly, given the nature of the infrastructure there, and I guess my long held and I think supported by some others in conversation previously, that we've got the levee banks that end at Murphy Street or at the milk station there, to be able to get a contribution from Taswater and maybe state government if they end up being involved in the other parts towards building a continuation of our bike track out to the Grammar boat sheds and a return out there, is, you know, whether there's something we can negotiate as part of that conversation.
CEO.
Long question.
Long question. The ability to get some additional infrastructure out of the deal.
Well, certainly from a state government perspective, there is a preparedness, and the Minister mentioned it when he was meeting with us a couple of weeks ago. No, it wasn't. It was the manager of infrastructure mentioned that would be certainly something that they're prepared to do as part of the master planning work that will happen through the vision, through the River Health Action Plan vision. So in terms of being able to make that area more recreationally accessible, definitely that's something that there would be a partnership as we are working with both levels of government around this implementation of the whole.
It just seems timely to bring it in as part of the conversation that we're having now.
Well, I don't know that lawfully we can in terms of making this this particular decision, but we can certainly include it in terms of that master planning work and as part of our general city deal and certainly the implementation of the vision that we're all working in together. So
my second part of the question was really in relation to selling $1. We're happy for selling for $1, but give us a credit for 736 against our 11.
Yes, no, we did explore that opportunity, and again, it's not really lawful to be able to do that in terms of a contract-style arrangement. I guess that we were going to be providing land in more problematic spaces, in my view, particularly Kings Park, for the first design. This design is far and away better than that. So I think that we're always going to have this as part of our contribution because our land is located in the right spaces. Again, I think we can't bring the two matters in terms of the contra and the commitment around the investment for our recreational infrastructure in terms of the decision today. But we're working well with partners. I'm sure that we're able to negotiate that outside of this.
So therefore, if we were doing the Kings Park and the other two lots of land, I assume the value proposition that we would have had on that would have been part of our contribution as well. So anyway, look,
General Manager Shane.
No. So our contribution was a cash contribution to pay for the new infrastructure. The land was in addition to that.
Thank you.
Question, Councillor Pentridge.
Once again, I would love to remind everyone, this morning we had the opportunity to have a look at a beautiful theatre. And I think it's as beautiful as I always remembered it in the times I've been there. Now, I just can't believe I won't be supporting this. So really, we're sort of wasting our time because we need unanimous support. Now, when I say I'm not supporting it, I believe that cleaning up and creating some silt ponds is a fantastic idea. If you look at all over the world, we can't keep giving the assets of the people of Launceston away for $1. I think there's got to be a better way that we can get some money, like even for these settling ponds, and use that money for things like our theatre, right? Now, so I'm not suggesting that we hold back, but we shouldn't just keep giving it away because that land is valuable land. We own a big chunk of it not far from there, which is the same material. Now, just continuing to give everything away for $1, another few years we won't have anything to give away. And we'll have nothing to earn us a quid either. Thank you.
Councillor Pentridge, I think I'll take that as a comment rather than a question, if that's okay.
Yep. Well, I was actually just saying, is there some other way of letting an important infrastructure go ahead, but to get a financial return that we can put back into this community rather than just hand it over and get some sort of paper credit for it?
CO mechanism for achieving the same outcome.
Look, there's certainly not a preparedness on behalf of Taswater to purchase the land. If it was to be leased and retaining our ownership, then we would own the asset, and the depreciation and all of the maintenance would technically go onto our book. So that wouldn't be an outcome that I would be recommending to the council. This is the cleanest option to ensure that they take the liability in terms of the contamination, but also take the ownership and future maintenance and obligations of the reservoir.
Thank you. Subsequent questions. Councillor Walker was next.
It was just a point of order to clarify, Chair. It's true that we just need an absolute majority, which is just a majority of 12 councillors rather than a majority of whoever's in the room.
Yeah.
So
thanks, Councillor Walker.
With due respect to Councillor.
Thank you. That's great. Good teamwork. So, Councillor Raze had a question. No, sorry, was there a question on this side? Councillor Harris, were you waving? Yep. Question?
Just a question regarding the use of the land if we sell it to Taswater in regard to the spoil that is there now that is a maintenance liability for us that we're handing on to them, which is pretty good. What do they intend to do for this? Are they able to use the holding the land without removing that contamination as part of what they do, or do they actually have to remove it and hence they're inheriting all that cost to then line it with something that then will hold the stormwater before it gets on? Are you aware of that?
Yeah, well, I can answer it to the extent that because it's infrastructure that they're talking about, then it will be a different standard to say if it was one of the uses that is permitted and discretionary within that zone, for instance, that would be considered a more sensitive use and then therefore require more extensive remediation of the contamination. So the fact that it's an inert use that basically no one will have contact, they'll be able to work with the EPA to be able to find a solution to be able to deal with it, whether that's sealing or whether that's some other means. But it would be a different proposition if you were dealing with a use where people were going to be spending, time, either working or otherwise on the site.
Question, Councillor McKenzie? No? All good. Councillor Deputy Mayor.
Thank you, Mayor. I'm just following on from my own understanding for this conversation. Is there any way that we can converse around the $750,000 into some sort of agreement that they do buy it from us and we use part of our contribution? Just for my own understanding, is there a part of that? There's no lawful conversations that we can have around, getting them to do something for it. There's no way that we can actually get them to pay or exchange direct debits.
No. I understand.
Through credits.
Yeah, I understand the question, and it was raised by Councillor McKenzie, I believe, in the workshop when we talked about it, and we did explore it. But no, and the lawyer in the room will tell me that it's not. We're not able to lawfully do that as part of this decision. So.
General Manager Eberhardt will add to that.
I think what's being lost here is we have a legislative responsibility to provide stormwater services in the combined area, and this, although we don't own the infrastructure, it's owned by Taswater. We have an agreement with them to provide that service we're responsible to provide. So I'm going to say the idea of them paying for it means that actually the agreement is that they can then recover that from us over time because it's part that infrastructure is required for managing stormwater, and therefore whether there's there's not a mechanism at the moment, but even if we were to push the responsibility back onto them, they would recover it over time through the current agreement.
Thanks, General Manager. Further contributions? Councillor Walker, question or speaking?
Speaking, thanks.
Sure.
Mayor. Oh.
I beg your pardon. Thank you, Councillor Dawkins. Councillor Harris, you've spoken a couple of times. Councillor Dawkins as the seconder. Thank you.
Thank you, no problem. Look, rarely has there been any element of council work that has brought more interest from the community than resolving any of the issues around the combined sewage. No, there's no doubt about it. This is just one step in a lot of people have sat around tables like this and tried to resolve this problem. So this is a practical measure that we can take for 1.635 hectares to be transferred at 65 to 85 Murphy Street to continue this process of being able to resolve this, what would be one of the most wicked problems that this council has ever had to tackle. So this is our commitment under TERHAP, that we will continue to find solutions. Whether we sell it for $1 or 700,000, it's irrelevant, because the community interest for this particular part of the puzzle is enormous, and we have to provide a solution. By doing this, we provide one step where we've got larger, what have we got? 10 meg storage, and we know how important that pump is. When the large amounts of precipitation occur in Launceston, if we can't pump it somewhere and store it, it's going to go straight into Cunnamalooka, Tamar Estuary. This is the very problem we are solving here today. So whether it's owned by us, by Taswater, by the state government, by the federal government, it's all us. It's our commonwealth. We own a portion of every single aspect of that, of all of those delivery mechanisms. So I think we're getting caught up on absolutely the wrong part of this plan. This is a very, very important step today, and we should all support it if we continue to speak for our communities.
Thank you, seconder. Councillor Dawkins. Councillor Walker.
Of course, the effluent to some degree still does go into the Cunnamalooka River. It's not as if it all gets removed, but nonetheless, it's a settling pond, and it increases the amount in which we can settle. But in a time of inundation, there will still be releases into the Cunnamalooka, albeit further away from the yacht basin. But having said that, I do agree with the sentiments of Councillor Dawkins insofar as once we joined the statewide body, which is Taswater, via a circuitous route, no doubt, with Ben Lomond Water and all that sort of thing. But we, for better or for worse, are part of a statewide solution, and this is contributing to that. I accept the point that we might wish to, monetise our assets, but in this case, this asset continues to be our asset, if you like, and we continue to benefit from it, whether we have the ownership or not. So I understand the sentiment that people are trying to pursue, but at the same time, yes, of course, in years gone by, we haven't always got the dividends that we wish as a co-owner of Taswater, and that's a continuing issue, though I do believe to some degree that's been addressed and will continue to be addressed. I'm no fan of Taswater borrowing large amounts of money. It seems reminiscent of other government business enterprises in the past that got to over $1,000 million, over billions of dollars that were owed, and got to the point where they were only maintaining the interest on that. Taswater are up to about $700 million or so that they've borrowed so far, and that will continue to rise. And we all pay for that through our water bills. So we have to be careful, and we vigilant as a co-owner of Taswater on that aspect of what they do, that they don't overcapitalise, that they don't gild the lily, so to speak, or gold plate what they're doing, but I don't think in this case they are. What I would like to see is that those dividends returned as they hopefully reduce their exposure to capital investment that is done through the money market. That, I think, is the bigger problem, because as a council who owns this asset, our dividends should increase, or the cost to the bill payer with Taswater should reduce. And that's what I'd like to see signs of. If this contributes to that, apart from contributing to the environmental outcomes, that's great. But at the moment, Taswater are spending large amounts of money, which they will do in this instance, to improve this facility. I don't think that it's a small solution. It's not part of a long-term solution. It's a contingent, small-term solution, and in a time of inundation, 1 million litres is not a lot. Thank you, Mayor.
Thank you, Councillor Walker. Councillor Pentridge.
Right. I appreciate what Councillor Wilkins indicated, and I don't normally like backing off something I believe in, but there's other issues here. On this drawing, it shows northern, middle, and southern. Why aren't we letting them have a northern one, which is up beside their plant anyway, and leaving the rest just in case it is needed for something else, and we can cash it in for $1. Not I say $1, cash it in for some financial reward. Why aren't we using the one would be obvious, which is right beside the plant?
Thanks, Councillor Pentridge. A question around the choice of the landlocked, Councillor and CEO.
No, so Taswater have done the work to identify this location as the preferred site in terms of the proximity to the T3 treatment plant. It is proposed that there would be a coffer dam established there, and the northern and southern and the remainder of the silt pond, if you recall, we would make available if it's needed for the sediment from the government silt raking, or rather dredging program. And obviously then if and when that happens, or after that happens, we've got choices we can make in respect of the balance of that site.
Thanks, CEO. Any other contributions around the table? We note Councillor Mackenzie left at 4:50. Councillor Harris, do you wish to close?
Just briefly to say thank you all for your discussion, and I think it's important to note that it is in fact a 10 million litre storage facility, and that was considered the sweet spot. I asked why couldn't it be 20 million and therefore hold twice as much. The costs of that was such that it is not the economic sweet spot. So Taswater are the experts in this. I am not an expert in the storage of stormwater that has the potential for sewerage in it as well. they are, and if that's the site they want, then I do feel that we are probably well served by making sure that they have access to it, and that then we get on with cleaning up the tamer, because that's ultimately what I think many of us would love to see. Thank you.
Thanks, Councillor Harris. We'll put the motion to the vote. All those in favour raise their hand. Those against? That is all councillors present. The motion is carried. In closing the meeting at item 17, I want to thank everyone for their contribution today. High-functioning teams allow for a variety of different viewpoints and perspectives. That is appreciated. How we bounce back from decisions is how we will be regarded as a high-functioning team. So thank you all for your contribution, all of which is valued. And we close the meeting formally at 4:53. Thank you.